morning. We'd like to welcome everyone here to the 29th Annual Jessup competition and the agents from the applicant and the respondent, the Yokum and Shangri side. The court would like to present its compliments to the agents for the excellence of their memorials, to say that we think the issues are well defined and that we look forward to your oral presentations. Let us also say that we would appreciate, given the time limitations here, if you would abbreviate the statement of the facts. Are agents for the applicant prepared?
Yes.
And agents for the respondent? Agents for the applicant may proceed.
May it please this Honourable Court, my name is Fiona Hudson and I appear with my co-agent, Mr. Darrell Williams, on behalf of the Republic of Yokum in this matter. The objects and purposes of the United Nations and of this Honourable Court, which was set up under its auspices, are the maintenance of international peace and security, and to this end the Republic of Yokum comes before this Honourable Court seeking three principal declarations. Firstly, that the Confederation of Shangri is obliged to try or extradite the Packham hijackers. Secondly, that Shangri is responsible for the acts of these hijackers both generally and in relation to the seizure of the Hasdrubal. And thirdly, that Yokum was justified in its interception of a Shangri aircraft. I will be dealing with the first of these issues, and my learned co-agent, Mr. Williams, will be dealing with the second two of these issues. Your Honours, members of Packham are guilty of several serious international crimes, and it is this which places an obligation on the Confederation of Shangri to either try or extradite them. Firstly, they are guilty of the crime of hostage-taking under Article 1 of the 1979 New York Convention against the Taking of Hostages. Should Your Honours, however, not accept that the laws of peace apply to the activities of Packham and that in fact the laws of war apply, it will be argued on behalf of Yokum that there are also breaches of the 1949 Red Cross Geneva Conventions, specifically under Article 147 of Geneva Convention 4. However, I should point out at this point in time that the memorial for the respondents has accepted that in fact the Geneva Conventions do not apply to the activities of Packham. I turn now to the Hostages Convention. It has been accepted by the respondents that in fact the crime of hostage-taking has been made out under the 1979 New York Convention against the Taking of Hostages. However, as this court is not bound to accept the agreed compromise between the parties, I shall elaborate how this offence has been made out. Under Article 1, there are three requirements expounded which are needed to be made out before the crime of hostage-taking has been committed under that particular convention. Firstly, there is a requirement of the seizure of persons, which we have in the instant case. Secondly, there is a requirement that those persons be detained. Clearly, the passengers of the Hasdrubal were detained over a period of time. Thirdly, there is a requirement that the purposes of the seizure and continued detention be to compel third parties to do or abstain from doing any act or thing. This element of third-party compulsion has been made out in the instant case by three demands of Packham. Firstly, there is the demand by Packham of recognition from the international community and from the media. This was the purpose of the seizure of the Hasdrubal, and it is clear that they were compelling the international community to recognise their aims and their objectives. Secondly, there is the statement by Dr. Mafarius that any intervention with the course of the ship would result in harm to the lives of the passengers, and it is clear that this is a form of compulsion upon those who would seek to intervene with the course of the ship, forcing them to abstain from intervention and using the lives of the passengers as bargaining power in this regard. Finally, there is an act of third-party compulsion in the seeking of asylum from the Confederation of Shangri when the ship docked in Tuluba, and this was again an example of the use of the seizure of the persons on board the ship in order to force Shangri to grant such asylum. Under Article 8 of the Hostages Convention, it is clear that there is an absolute obligation to try or extradite persons who have committed this particular act when those persons are found on the territory of a state party. And it is clear that members of Packham can be found on the territory of the Confederation of Shangri.
Is there a priority established under the Hostages Convention regarding jurisdictions claims?
There is no particular priority per se established under the Hostages Convention. Under Article 5 of the Convention, various grounds are elaborated for jurisdiction. These include where the offence was committed on the territory of a particular state, where the state was a victim in the sense that it was compelled to do a particular act or thing. There are other grounds such as the nationality of the perpetrators concerned. Although these particular grounds of jurisdiction are enumerated in a particular order, it has been stated by commentators that there is no particular hierarchy concerned under Article 5 of this convention.
So what is your conclusion? Is the applicant free to extradite to any other country as it wish?
The respondent is free under the terms of Article 8, if it wishes and if it does not try, to extradite the hijackers to another state which has jurisdiction under Article 5. And Yokum would be an example of a state which has jurisdiction under Article 5, as it is a state where its nationals have been subject to the act of hostage-taking. However, Shangri itself has jurisdiction to try the matter on the basis that members of PACM are found upon its territory, possibly on the basis that members of PACM are stateless persons permanently resident on its territory. So, should the Confederation of Shangri not wish to extradite, it is under an absolute obligation to try the hijackers, and it has jurisdiction to do so. It is clear that there is no justification for not adopting one of the two alternatives, and also that Shangri cannot claim that it has fulfilled its obligations under the Hostages Convention by sending PACM hijackers to SARC. Under the terms of the Convention, it is necessary for a state to have jurisdiction, for it to be a state party, as well as having one of the bases of jurisdiction enumerated in Article 5 of this Convention. And in the instant case, we have no evidence that SARC is in fact a party to the Hostages Convention, and thus it would have no jurisdiction to try the PACM hijackers, although it may have jurisdiction on other bases, perhaps in relation to other crimes. It certainly doesn't within the framework of this particular convention.
Well, in the compromise, it said that there were 10 citizens of 10 countries in addition to that of Yokum.
That is correct.
And I believe that among those 10 nationals, there were some from SAC. So they have some grounds, I believe, to demand extradition of some of the hijackers.
Your Honour, it is not actually stated in the compromise that SARC nationals boarded when the ship docked at Tuluba, although this may be a reasonable inference. However, the point that I seek to make is not that SARC is not covered by one of the grounds enumerated in Article 5, but that it is not a party to this particular convention. And the wording of Article 5 states that a state party is obliged to obtain jurisdiction by enacting legislation pursuant to the convention. That is how it obtains jurisdiction. And as SARC is not stated as a party to the convention, it thus has no basis for jurisdiction, even though on a factual level it may be covered by the grounds enumerated in Article 5. But furthermore, in this regard, it is submitted on behalf of Yokum that even if SARC had a basis of jurisdiction in the instant case, the purported extradition to SARC is a sham, as we have statements by the President and Chief Justice Minister of this state that he intended to set free the hijackers as, in his own words, heroes of the revolution.
Madam Agent, may I interrupt for a moment to ask you, what is the legal effect of the unilateral statement of the Minister of SAC in making that statement?
Mr. President, it is clear that on an evidentiary basis, the court is entitled to look to that statement as evidence of what the state of SARC will do in the future, not simply as a binding obligation, as was dealt with in the nuclear tests case, but on a purely factual and evidentiary basis. A statement by a head of the executive to the media can be dealt with in order to determine what that state either has done in the past or intends to do in the future. And I'd refer Your Honour to the Nicaragua case, where it was pointed out that although such statements to the media may occasionally have a lower evidentiary value, the court may take them into consideration and may construe them with more formal documents, such as, for example, a diplomatic note, in order to gain the overall intention of a state at a factual level. I would not seek to argue that, in fact, the statement by the President is a binding legal obligation in any sense. The Republic of Yokum does not seek to rely on it on that basis.
It would recognize the fact that statements are often made for purposes of domestic political purposes, rather than to have an internationally legal effect?
Your Honour, we are not seeking to bind the state of SARC to the comments made by the President, but simply to introduce them on an evidentiary basis in order to ascertain what the intention of the executive of SARC was. So we are not seeking to say that it is bound to release the hijackers when they are found upon its territory, simply to indicate what a possible course of action was going to be conducted by the state of SARC.
Is there not another problem here, perhaps, and that is that in the extradition, Shangri's motivations might be different from those of SARC's, and that Shangri could, in good faith, extradite the terrorists to SARC, and that SARC's motivations are yet somewhat undetermined and undeterminable, and that the requirements upon Shangri as set forth in the convention have been met without respect to the motivations of SARC.
Your Honour, the statement by the Chief Justice Minister and President of SARC was made prior to the extradition, and it was clear that Shangri would have been aware of this statement before it sent the 3 hijackers to SARC to be freed. In any event, it is clear from the subsequent release of 4 Packham hijackers that Shangri could not have been acting in good faith in sending only 3 hijackers to SARC. If it believed earnestly that SARC was going to fulfill its obligations and to put these hijackers on trial, then why did it only send 3 of them? This is clearly an inconsistency on the part of the Confederation of Shangri.
Well, you know, but I'm sorry. Actually, although it's not said in the compromise, the diplomatic note which was sent 2 days before the statement by the President should contain some reasons for the extradition. And normally, if we are coming from the assumption that the state should either punish or extradite a person, and if it's extradite a person to another state, it means that that state should punish it. And the respondent may came from this basis. That's why I just sent those 3 hijackers to SARC.
Although there was a diplomatic note from the state of SARC containing 2 bases for extradition, namely under either the Geneva Conventions or the Hostages Convention, as it has already been pointed out, SARC does not have a jurisdictional basis under these, and secondly, that the Confederation of Shangri is not entitled to look to the diplomatic note alone in order to determine whether SARC was going to try the hijackers or not. And it should be pointed out that it also has the diplomatic note from the Republic of Yokum, and there has been no statement by the Republic of Yokum that it has no intention to set the hijackers free. And in the instant...
Nothing was said in the note about the intention, because it's a possible intention to set the hijackers free. The diplomatic note asks only for the extradition, that's it.
That is correct, Your Honour. However, it is contended on behalf of Yokum that the Confederation of Shangri must look to the statements by SARC in their entirety. And thus, it must construe both the diplomatic note, which prima facie shows a good faith intention on behalf of SARC to try these hijackers, but also in the light of the statements made later, which, although they have a slightly weaker evidentiary value, must be examined in order to determine the full intentions of the state of SARC. In any event, it must be noted that Shangri clearly did not fulfill its obligations in relation to the other 4 hijackers, in fact by setting them free and granting them asylum. In the terms of the Hostages Convention, it is clear that there are limited bases upon which asylum can be granted, and I would refer Your Honours to Article 9 of this particular convention, which enumerates the bases upon which asylum can be granted. The Confederation of Shangri has not made out in its written brief any particular grounds upon which it can grant asylum as described by Article 9. For example, there is no evidence that sending the Packham hijackers to Yokum would in any way prejudice them on the basis of their political beliefs. Although the state of Yokum has been subject to various attacks, as have other states in the world community, this is no basis for inferring that in fact the Packham hijackers would not be subject to a fair judicial process in the state of Yokum.
But, Madam Agent, did not the respondent set forth in his memorial its reason, and that is that in the framework of general international law, and in particular customary international law, they were following a line of response which might be characterized as self-help, and that they did not rely upon the convention itself, and that rather they relied upon general international law.
Mr. President, the Republic of Yokum contends that even if Shangri tries to justify its actions in releasing the 4 Packham hijackers on general customary international law, that it was not entitled to do so. This argument will be elaborated further by my co-agent Mr. Williams. However, I should point out that the Confederation of Shangri cannot rely, for example, on Article 60 of the Vienna Convention of the Law of Treaties as justifying its actions, which it has attempted to do. It is clear that although, if the court does not accept that Yokum has not violated the Hostages Convention in intercepting the aircraft, and we contend that it hasn't, it is clear that should the court not accept this and hold that Yokum has violated Article 16 of the Hostages Convention, this does not give Shangri the right to suspend its obligations under this convention, as it is a multilateral convention, and for Shangri to release 4 hijackers is not simply a countermeasure directed at the government of Yokum. It is an action which is inflicting harm on the rest of the international community. It is clear that the...
Confederation of Shangri did arrest the 7 hijackers immediately the other day after the ship came into the port, yeah? Isn't it so? So it just made certain actions to fulfill its obligation.
It may have commenced its obligations, for example, under Article 6 of the Hostages Convention, to arrest the hijackers. However, its subsequent actions in setting them free are clearly contradictory.
But these subsequent actions were just some kind of response or reply to the actions of your country with regard to 3 hijackers and the intercepting of the civilian plane. Isn't it so?
That is correct that it was justified by Shangri as a response. However, it is argued on behalf of Yokum that no such justification can be made at international law. It is clear that the act of setting the 4 hijackers free was a measure which was going to have an effect on the international community far above what effect it was going to have simply upon the Republic of Yokum. Packham has been attacking both the state of Midbari and it has been attacking states surrounding that of Midbari and including Yokum's national and economic interests. In these circumstances, setting the hijackers free to continue their terrorist acts against various other states cannot be justified as a countermeasure directed solely at the Republic of Yokum.
Can we go back a little bit? Where was the hijacking committed?
The hijacking was committed, Your Honour, on the high seas.
And on what boat? Under what flag?
It was under the flag of the state of Melbourne, Your Honour, which clearly also would have jurisdiction in the instant case and had it sent an extradition.
What's the relationship between PACM and Shangri?
The relationship, Your Honour, the relationship was such that Shangri housed Packham on its territory, and in terms of the responsibility of the Confederation of Shangri for their acts, I would point to the arguments of my learned agent, Mr. Williams, which will be dealt with shortly. But that certainly was the relationship, that Packham was operating from Shangri territory.
Could you try to identify the relationship between the PACM and Shangri and why Shangri can be held responsible, apart from the fact that the hijackers was found on the territory of Shangri? Are there any other reasons that can hold Shangri responsible?
Your Honour, there will be several principal grounds on which it will be argued that Shangri is in fact responsible for the acts of Packham. Firstly, on the basis in relation to the general raids, because it had knowledge of the activities of Packham and because it did not meet standards of due diligence in attempting...
Packham, what do you mean?
It was clear that many states sent diplomatic notes to the Confederation of Shangri notifying Shangri of the whereabouts of perpetrators of a variety of offences committed against those states.
They have knowledge of the hijacking prior.
It did not have knowledge of the hijacking, Your Honour. However, it will be argued that there are further bases for state responsibility, namely complicity in Packham's actions by failing to meet its obligations to try or extradite the hijackers, and by releasing them, this was a tacit approval of those actions. These arguments, as I've said, will be dealt with in more detail by Mr. Williams. However, if Your Honour wishes me to elaborate them further, I can do so. But these will be the principal arguments on the issue of state responsibility.
Wait for those arguments.
Certainly, Your Honour. Should Your Honours not accept that the Hostages Convention is the appropriate regime governing the activities of Packham, there of course are further bases upon which there is an obligation on the Confederation of Shangri to try or extradite the Packham hijackers. Should the laws of war apply, and I should point out that the respondents have conceded that they do not, but in the event that this court believes that they do, it is submitted on behalf of the Confederation, on behalf of the Republic of Yokum, that there have been grave breaches of the 1949 Geneva Convention No. 4, in that there have been acts of willful killing and hostage-taking committed by members of PACM in the course of their seizure of the Hasdrubal.
Are you arguing that the Geneva Conventions are applicable in the present incident?
Your Honour, the Republic of Yokum submits that they are not. However, it is an alternative argument should this court in fact hold that the laws of war do apply. However, the Republic of Yokum submits that they cannot. Firstly, because PACM does not come within the regime of the 1949 conventions per se, which under Article 2 it is envisaged apply to armed conflicts between states. Secondly, PACM does not come within the regime of the protocols to these conventions. Firstly, because the Shangri and Yokum are not parties to the protocols, and also because PACM is not a self-determination group as defined by paragraph 4 of Article 1 of Protocol 1. And thus it is submitted that as it is not a self-determination group, as there is no evidence of objective factors making it such a group, that it is not covered by this regime.
Madam Agent, you state with a certain degree of certainty that it is not a self-determination group. Is that simply Yokum's position, or do you have some other evidence to offer us?
Certainly, Mr. President. The requirements of self-determination group are twofold. There are both, I see, Your Honours, that I have run out of time. If I could perhaps just continue this argument?
Please.
Thank you. The hallmarks of self-determination group are firstly a subjective element, namely a sense of common identity. And it is admitted that PACM does have a sense of common identity. However, it is of extremely dubious value simply to look at the self-serving rhetoric of these terrorists in order to determine their status. And I would point to the case of Nicaragua and the United States.
As compared to the statement of the Minister of Justice of SAC.
We are here looking at a statement which is, in a sense, for the interest of the members of PACM. It could be said that the statement by the Justice Minister of SAC is, in a sense, a statement against interest. And in the case of Nicaragua, it was pointed out that such statements are of higher evidentiary value than those statements which simply serve the maker concerned. So in the instant case, it would be clear that there would be a higher evidentiary value to be placed on the statement of the Justice Minister of SAC. But in any event, it is clear that it is not simply enough to have a subjective sense of identity to constitute a self-determination group. In the Western Sahara case, various objective factors were pointed to as hallmarks of a self-determination group. These would include a common language, perhaps a common ethnic origin. Other hallmarks might include religious characteristics which are similar of a particular group. And it is clear that in the instant case, there is no evidence that PACM has any of these particular characteristics. Although some may categorise it as a national liberation movement because it seeks to overthrow the government of Midbari, this is not sufficient for it to constitute a self-determination group. In other words, they are not a people as envisaged by paragraph 4 of Article 1 to the protocols. It is possible for a group to seek to overturn a government on a purely political basis, and it is possible that PACM operates on this basis. But we have no evidence that it has any of the hallmarks of a people and that it has none of the objective characteristics of a self-determination group.
Are the Geneva Conventions applicable between Shangri and Yokum?
They would be applicable in the case of an armed conflict between Shangri and Yokum.
What is the scope of application under the Common Article 2 of the Geneva Convention?
Under Common Article 2, it is clear that the conventions govern armed conflict between state parties, and in the event of armed conflict between Yokum and Shangri, then these conventions would be applicable.
What's the definition of armed conflict?
Armed conflict clearly includes, in a sense, attacks which are of such a scale and of such escalation, and if I could point to the definition of perhaps Professor Brownlee in this regard, that it can be said that something akin to a state of war exists between the two parties. And so, in the event that there was a direct conflict between Yokum and Shangri, it would be clear that there would be a case of armed conflict if it was of such intensity and of such periodicity.
Do the Geneva Convention expressly provide that they do not apply to sporadic fightings? Are there such express provisions in there?
Your Honour, I can point to no express provisions. It is clear that the interpretation of armed conflict has always been that there must be attacks of sufficient intensity and sufficient scale.
In your view, the present incident has not met that standard.
As Your Honour referring to the activities of the members of PACM, the activities of the members of PACM could be said to constitute perhaps sufficient scale to be an armed conflict. They would certainly be of sufficient scale to constitute an armed attack, and I would refer Your Honours to the court's decision in the Nicaragua case, dealing perhaps more specifically in relation to armed attack under the guise of Article 51 of the UN Charter, where they stated that raids by marauding bands, where they were conducted on such a scale and of such intensity that they were similar to those of regular armed forces operating on a guerrilla basis, could be said to constitute an armed attack. And if they are operating at such a level of intensity that they could be said to constitute an armed attack, then perhaps they could constitute an armed conflict.
So if you viewed the continuous hostilities between PACM and the Yokum, and then would you be able to see the hijacking as an incident of this series of armed conflict?
It could be characterised as such. However, I would point Your Honour to my earlier submissions that in fact PACM is not within the regime of the Geneva Conventions because it is not a group covered by those particular conventions. In other words, it is
PACM based?
PACM is based in the Confederation of Shangri. And although the Confederation of Shangri bears responsibility for the activities of PACM, this is not enough to make the acts imputable to Shangri as an act of state, and thus we are not seeking to argue that there is an armed conflict between Shangri and Yokum. So although we seek to suggest that Shangri is responsible for the acts of PACM, we are not seeking to suggest that they are in fact acts of state by the Shangri government.
I'm having a little bit of difficulty trying to pin down how you would characterize the legal nature of PACM. What is it under international law?
There is no legitimising factor under international law for the activities of the members of PACM.
Not for the activities. The group itself, what is its legal character?
I would suggest, Your Honour, that it has no legal character which legitimises its activities. In other words, it is not a self-determination movement.
If it doesn't fall under the Geneva Conventions, then you argue it doesn't fall under the activities of Shangri as a state, then does it not necessarily come under the protocols? It must have a status.
Your Honour, the protocols envisage groups exercising a right of self-determination against colonial domination, alien occupation and racist regimes as being covered by their scope. Now, it is possible that there are many national liberation movements which do not meet these criteria, and it is clear in the instant case that PACM's activities are not such that it can be characterised as a legitimate self-determination movement. Thus, it is not covered by the regime of the Geneva Conventions, and its activities may be characterised as common crimes as they are in breach of various other conventions such as the Hostages Convention.
Does your submission that the Geneva Conventions are not applicable have anything to do with the fact that you have not enacted national legislation to implement the Geneva Conventions? And could you elaborate on that point, particularly in relation to the Vienna Convention on the Law of Treaties, Article 60? Thank you.
Although we have not enacted the Geneva Conventions in our legislation, it is clear that this would not preclude us from trying PACM had they been extradited to us under the Geneva Conventions. It is clear that there is a distinction between international jurisdiction, which Yokum has simply by being a party to the Geneva Conventions and arguably would have at customary international law anyway, and between the possibility of trying offenders by having a municipal crime correlative to the particular international regime concerned. I would point Your Honours to the analogy of piracy, where although there was universal jurisdiction for piratical act, various states have their own municipal law definitions of piracy, which vary somewhat from the international definition. And provided a state gains international jurisdiction to try an offender, if it has a municipal law upon which it can try them, then it is entitled to use that municipal law. and thus it has, if it seeks extradition, it cannot be said that it doesn't have the effective means. In the instant case, Yokum has enacted the Hostages Convention, and it would be clear that within the law of the state of Yokum there is a crime of hostage-taking, and this would be sufficient in order to try the members of PACM for hostage-taking under the Geneva Convention.
Did you wish to refer to Article 60 of the Vienna Convention on the Law of Treaties?
Your Honour is referring to the claims by agents for Shangri that if a state breaches its obligation under a particular treaty, then another state is entitled to suspend its obligations under that treaty. In relation to the activities of the Republic of Yokum, we argue that there have been no breaches of any of the treaties to which it is a party with the Confederation of Shangri. In particular, there have been no breaches of the UN Charter, no breaches of the Hostages Convention, and should the Geneva Conventions apply, that there have been no breaches of the Geneva Convention.
A non-enactment of the convention is not a breach, in your view?
It is certainly not a sufficiently substantial breach to enable Shangri to suspend its obligations. It is clear that under the terms of Article 60 of the Vienna Convention on the Law of Treaties, that the breaches concerned must be of a sufficiently serious nature. In other words, there must be a breach of the fundamental terms of the treaty, and non-enactment of the Geneva Conventions would not constitute such a fundamental breach when there is sufficient municipal mechanisms to try people under the Geneva Conventions. It is not necessary to have all the procedural aspects of the Geneva Conventions enacted into municipal law when it is clear that at least the offences are there within the municipal law of Yokum itself.
Legal authority to support your statement?
That it is possible simply to have sufficient municipal legislation. I would simply refer, Your Honour, to my analogy with piracy, where the distinction between having municipal means of trying an offender and between having international jurisdiction to try that offender are disparate. So in other words, it could not be said that it is a breach of the Geneva Conventions not to have enacted them where there are clearly provisions which have, if not ostensibly enacted the Geneva Conventions, where there are municipal provisions which have effectively enacted them. So in the instant case, Yokum has sufficient municipal law to cover grave breaches under the Geneva Conventions and to have them as crimes within its legislation. And in these circumstances, it cannot be said to have breached the Geneva Convention sufficiently to enable Shangri to take the action it did in releasing 4 of the hijackers.
In light of the fact that we have gone over, I think we, in all fairness to the respondent, should just thank you very much for your presentation, and we'll wait for the conclusion in your rebuttal for any summary that you may have.
Certainly, Mr. President. That concludes the submissions on behalf of the applicant in this particular matter.
May it please the Court, Your Honours, my name is Darryl Williams and I appear also as agent for Yokum in this matter. I'll be dealing with the issues of state responsibility on the part of Shangri for the actions of PACM which are referred to in the compromise in this case. That is 2 classes of action. Firstly, the ongoing series of raids which was conducted by PACM into the territory of states neighbouring Shangri and which involved harm to Yokum nationals and Yokum economic interests. And secondly, in relation to the incident of the Hasdrubal itself, for it's admitted that Shangri is responsible for both of these classes of acts. Secondly, I'll be dealing with the issue of the diversion of the Shangri aircraft, which was carrying the individuals responsible for these acts to a safe haven in Sark, where they were to be set free. To turn firstly to the issue of state responsibility, the issue of responsibility for the acts of PACM in conducting raids which have involved damage and harm to Yokum economic interests and nationals is established because all states have a duty at international law to ensure that their territory is not used as a base for harm coming to neighbouring territories. In a general way, one can look to the trail smelter arbitration between Canada and the United States to establish the general proposition that a state may not allow its territory to be used in such a way as to cause harm to neighbouring territories. One can look even more specifically to the series of arbitrations between the United States and Mexico in the 1920s and 30s, which is perhaps the richest source of law in relation to state responsibility, and find that these arbitrations carry a consistent principle, and that is that Mexico did have a responsibility to ensure that its territory was not used in such a way as, for example, in the Texas cattle claims, as to bring about damage to either nationals or the economic interests of the neighbouring United States. The Texas cattle claims is a particularly interesting case because it establishes that such a basis of claim need not be based on actual complicity of the Mexican government in that case, but in relation to the activities of a group known as the Kickapoos, where these groups were held to be entirely independent of any government authority or action, but nonetheless the failure of the Mexican government to restrain the activities of these groups was nonetheless sufficient to found responsibility on the part of Mexico at international law. And it's submitted that this principle is in accord with international law as it is and ought to be, that this principle has now been embodied as customary international law, inasmuch as it has been accepted over time by the authors on the state responsibility, and indeed that the very principle has been incorporated in the International Law Commission's draft articles on state responsibility, promulgated in 1981. And indeed, I would refer Your Honours to the commentary to those draft articles promulgated by the International Law Commission for the proposition that not only is there such a duty, but that states have such a duty, must perform such a duty to a level which is acceptable to the international community. That is, that there is an international minimum standard which all states must apply in dealing with the groups such as PACM on their territory. Support for that proposition is again from commentary to specifically Article 3 of the Convention, where the International Law Commission suggested that all states, by virtue of taking on sovereignty, having the rights of sovereignty, must also accept the responsibilities flowing from sovereignty, and therefore by assuming the rights over the territory over which sovereignty is manifest, that the state has a duty to all other states to provide a level of protection to those states in regard to what happens on that territory over which sovereignty exists.
Mr. Agent, your sources are undeniable but rather old, particularly since the era after the Second World War and with the advent of movements of national liberation. There may be some contrary state practice with respect to the issue of state responsibility. Can you cite us any authority to support your proposition in the context of the struggle between Israel and the Palestinian Liberation Organization and between South Africa and the various movements seeking liberation in South Africa?
Well, Your Excellency, it's argued that there is a distinction to be drawn between those conflicts and the current one, because in particular in relation to the activities of SWAPO.
Before you draw the distinction, can you tell me whether or not there's any consistency there?
The consistency, Your Excellency, is on the basis that these groups form legitimate national liberation groups who are engaging their activities directly against those against whom they have a complaint, or against the governments which they allege are suppressing their right to self-determine.
Would it therefore be fair for the court to conclude that, in fact, there is an exception to the rule of state responsibility in the context of national liberation movements?
Only, Your Excellency, if the court were to determine that such a rule was limited to the extent that a group must establish that it has a legitimate right to self-determine, and furthermore that it was in exercise of that legitimate right that the activities which were alleged to be controlled.
Well, Mr. Agent, I don't think the court's determined whether or not the Palestinian Liberation Organization is a legitimate self-determination movement, or SWAPO, or any of the other South African groups. I think that would be beyond the bounds of this particular controversy. So therefore, I think we have to go by the unilateral declarations, or at least the world view of those movements. If we found then that PACM was in fact a self-determination movement, would your state responsibility argument go down the drain, so to speak?
No, it wouldn't, Your Excellency, because PACM has taken its activities beyond the struggle which it is purportedly involved in. And this is where it is to be distinguished between, from, for example, SWAPO and the PLO, both of which have recognition, of course, as observer status at the United Nations. But nonetheless, once their activities go beyond a legitimate struggle for what they are seeking to fight for, then they lose the protection that they might have had for being a national liberation movement with some justification. And accordingly, in the instant case where it's clear that PACM's activities are directed not merely against Midbari, but also against territory of other neighbouring states, and in particular Yokum, which has no dispute with Packham and which is not involved in the suppression of Packham's right to self-determination, which is expressed by Packham itself to be merely in the state of Midbari. And accordingly, its actions which go beyond its legitimate right must also be regarded as those which Shangri is under a responsibility to suppress. Accordingly, one can argue that even if the status of a national liberation movement accords it some capacity to struggle against the government with which it has a dispute, it would be inappropriate for this court to declare that that capacity was unfettered by the bounds of international law, and in particular that that capacity extended to the involvement of civilians of innocent third states. And accordingly, Shangri is responsible, at least to the extent that Packham has involved such innocent civilians of third states in its conflict, even if this court were to hold, contrary to the submission of my colleague Ms Hudson, that Packham was a legitimate self-determination group.
Of the cases which you have cited, were the territorial states in effective control of their own territories?
In the near claim which I've referred the court to in the memorial, Your Excellency, it can be argued that in fact the state was in effective control. But one can compare this case with, for example, the Meade claim, the Almaguer claim, and the Boyd claim, which are referred to by agents of the respondents in their memorial as establishing a proposition that where one can perhaps draw an analogy between dealing with a very remote area where it's difficult to exercise control and dealing with an area bound by civil strife where it's perhaps equally difficult to exercise control. But it's worth pointing out that in all of those arbitrations, in all of those three that are referred to by agents of the respondent, in fact a finding of responsibility was ultimately held, because while the arbitrators in those decisions recognised that some allowance may be made for difficulties in effecting arrests and indeed in prosecuting such incidents, that nonetheless the failure on the part of the Mexican governments in those claims to take any action whatsoever was sufficient to found responsibility. And it's argued that in the instant case, a very similar failure can be demonstrated, that in fact Shangri's failure to take any action found responsibility upon it, notwithstanding the difficulties that it may have faced.
Is it correct in the cases that you've cited that at least there were no evidence to show that the governments involved did not exercise effective control over their territories?
I'm sorry, Your Excellency, could you rephrase?
In the cases that you have cited, is it correct that there were no evidence to show that the territorial states were not in effective control over their own territories?
Not that they were not in effective control in terms of having sovereignty and being able to exercise sovereignty, Your Excellency, but for example in the Meade case, the difficulty of effecting control over the territory was demonstrated by the fact that the murder which was complained of was committed 80 miles from the nearest town in rugged country, where it would be clearly difficult for a state to exercise control over that portion of its territory. And I argue that it's analogous in that situation. One can draw an analogy between that and the incapacity to deal with territory because it may be in a state of civil war.
Yes. Do you have any cases that shows there was a similar situation like the present case?
I'm not aware of any particular case which shows a state alleging that it had no capacity whatsoever to deal with an incident because of civil war.
Except that the present case, Shangri has no control whatsoever. Did I think
No, I
you
don't
did use that word.
I do not accept that proposition, Your Honour. I was merely staging the argument in response to the allegation made by Shangri. The next stage of my argument is to go on and point out that in fact Shangri has demonstrated that it has considerable control over its territory by in fact its arrest of the 7 Packham hijackers from the very Packham stronghold in its territory in the city of Toluba, which is one of the areas over which it alleges that its control is limited. And accordingly, the Confederation of Shangri has demonstrated the very contrary position to that which it claims was the case, and that is that it is quite capable of stepping in and dealing with the activities of Packham when it so chooses and when it regards this as in its best political interests, presumably, because the differential between its actions in relation to the Hasdrubal and its mere throwing up of its hands in an allegation of incapacity in relation to the earlier incidents is a conflict which this court should consider very seriously as giving rise to an implication of bad faith on the part of the Confederation of
Do
Shangri
I
in the earlier
understand
incidents.
from your submission then that the court should hold Shangri responsible irregardless of the actual situation? That there was a civil strife and that it's admitted in the compromise that Shangri does not exercise effective control, that the state responsibility is such that it's absolute in this case.
That is the primary submission which I made first, Your Honour. And in the alternative, I also argue that even when a test of due diligence is applied, as argued for the Confederation of Shangri, that even such a test has been failed by the clear fact that no action whatsoever was taken. And it was in that context that I referred, Your Honour, to the Mexican arbitrations and also the clearly demonstrated capacity of Shangri to act, which is perhaps analogous to the prior demonstrated capacity of Iran to take action in relation to the seizure of embassies prior to the Iran hostages case. Seizure of the United States Embassy was similarly a demonstration that in fact the state did have the capacity to act and chose not to act. And it is on that basis that I suggest that in this case the due diligence test is failed because Shangri clearly did have the capacity to act and therefore chose not to act. And indeed, in relation to the Hasdrubal incident, one can further argue that because of the basis of its failure in relation to previous acts, that this amounted to an encouragement of Packham to engage in illegal activities directed against foreign nationals and foreign economic interests. And one can again draw an analogy from the Texas cattle claims, which, as I've already argued, is one widely accepted by learned jurists in international law as a stating the position at international law of state responsibility. That it was held that the Mexican government's failure to deal with previous actions amounted to an encouragement sufficient to found responsibility for future incidents. And it is on that basis, firstly, that responsibility for the Hasdrubal incident is argued. And there is a further basis that Shangri's failure to deal with the actual hijackers of the Hasdrubal, once it had them in their possession, also demonstrates a failure to provide justice and a denial of justice sufficient to found state responsibility. And even if Shangri were to succeed in its allegation that it was entitled to grant asylum to these individuals, it's argued that by drawing an analogy from the Coatsworth and Powell claims and from similar claims in the United States Mexican arbitrations, and indeed from that particular claim, which was the one between Great Britain and Colombia, that it's clear that a state which grants asylum or pardon to a criminal and thus denies all other states the opportunity of seeking redress against that individual must take upon itself the responsibility for that individual's acts. And accordingly, there are two bases upon which it's argued on the Confederation that the Confederation of Shangri is responsible at international law, not only for the raids by Packham, but also for the seizure of the Hasdrubal.
Mr. Regent, your submission gives the idea that you reject the right of the national liberation movements to have struggles for their liberation. Can you elaborate on that, please?
Your Honour, it's not that Yokum rejects the right of legitimate national liberation movements to struggle legitimately towards their ends. It submits firstly that Packham has not demonstrated that it is such a movement and that there is insufficient evidence for this court to draw such a conclusion. And
Mr. Regent, but in compromise said that this movement is recognized by 4 states as such.
With respect, Your Honour, it's recognised by 4 states as the government in exile of the state of Midbari. But this is not to say that those 4 states recognise that it's that the basis of such recognition is on the basis of it being a national self-determination group. Such recognition can, as is often the common practice of states, be on the basis of a political claim that Packham may have as to government of Midbari. And there are numerous examples of governments continuing to recognise groups, for example, of the Pol Pot regime in Kampuchea, all around the world, where groups which are not in effective control of the territory are nonetheless recognised by other governments as a government in exile because of their political claim over the territory, which is to be distinguished from their claim as a national liberation or self-determination group, which must be argued on a quite different basis. And in any event, Your Honour, it's argued that nonetheless, even where such a right is conceded, that even if Packham were to have a right to struggle for the liberation of Midbari, such a right does not extend to allow it to involve itself in activities against civilians of third-party states and to engage in activities which are not specifically directed towards that end. Because once it steps outside the mantle of a group struggling for self-determination, then it has no more protection at international law than does any other rebel group.
I'd like to follow up on that for a moment, Mr. Agent, and to ask you, would you characterize the Palestinian Liberation Organization as a self-determination movement in the context you've spoken of, a self-determination movement?
Personally, Your Excellency, although it's not a matter before this court, of course, yes, I would, in that the Palestinian Liberation Organization does satisfy the general requirements of the Western Sahara case, that it is...
But surely there was a point in the development of the Palestinian Liberation Organization, the PLO, where it didn't meet those criteria, that it was emerging as a self-determination movement. Wouldn't that have to be the truth?
I would suggest, Your Honour, that while it may not have achieved widespread recognition as such a group, that it would, from its very beginnings, have been able to demonstrate that it had the required characteristics of such a group, which are the characteristics of common cultural heritage, of common ethnic origin and common religious understanding, which were those referred to by Ms. Hudson, and that the group is able to demonstrate those from the very beginning. And it's only by demonstrating those, in fact, that it can hope to gain recognition. But a group which is unable to demonstrate those at all is not entitled to recognition at international law as such a group.
But that must come at a certain point in time, must it not?
I argue, Your Excellency, that in fact it must be an inherent part of the group from the start.
But we recognize it at a certain point in time. It wasn't always apparent.
Certainly we recognise it at a later point.
And then isn't it possible that with PACM, taking your position, assuming your position is correct, that we may not have recognized it yet, but that it does have the beginnings of it, and that, like the PLO, which clearly has gone outside of Israel in an attempt to pursue its self-determination movement, similarly, PACM perhaps is engaged in the same thing. And the question may then turn out to be, what is its principal motivation, and not what are some of its extraneous acts?
Yes, Your Honour. It's argued that even if one was to accept the view that that recognition is in some way relevant to the PACM status as a legitimate self-determination group, that nonetheless it ought to be able to demonstrate to the satisfaction of this court that it has sufficient hallmarks of such a group before this court were to take the fairly significant step of saying that for the purposes of this arbitration, that it in fact amounts to a self-determination group. So what effectively the Republic of Yokum is saying is that there must be a burden of proof upon Shangri which seeks to rely on the PACM status, which they may allege exonerates them from state responsibility to deal with PACM, that there is a burden of proof which cannot be satisfied to show that PACM is in fact such a group, and that the burden is not a question of recognition, but a question of the actual elements of a self-determination group which are inherent from the very beginning of such a group. And indeed, without such characteristics, a group may not pursue self-determination so as to gain later recognition, because it must have the fundamental starting point that would justify its activities. If I might turn very briefly, Your Honours, because my time, I understand, is very nearly expired, to the issue of the use of force by Yokum in relation to the Shangri aircraft, which was carrying these individuals to a safe haven. It's argued that this use of force was appropriate and indeed necessary at international law. It is not a contravention of the Hostages Convention, as argued in the memorial for the Confederation of Shangri, because all Pacific avenues had been addressed by Yokum. It had sought in a diplomatic note that Shangri arrest the hijackers. It had sought their extradition, and yet Shangri unilaterally determined that notwithstanding all of these Pacific addresses by Yokum, which indeed went on to the previous raids, that it would nonetheless send these individuals to a safe haven, leaving Yokum no opportunity to deliberate, in the words of the Caroline case, no moment of hesitation, and an immediacy and a necessity of action, because in terms of defending its right and its nationals, it had to act then or lose any ever opportunities that it may have had once these individuals were set free in the state of Saab.
Mr. Agent, you know quite well that the Charter of the United Nations provides for the peaceful settlement of these disputes. You mentioned only two methods of your country trying to settle the dispute peacefully. I mean, the demand for extradition and some other things. But it's only two things. There are so many possibilities of peaceful settlements. Why didn't your government try to use some others? And just they didn't try, I mean, your government didn't try to think or to ponder out some other possibilities, but not to use the force, as you said it was, you have no other way but to use the force.
I should draw the court's attention to the fact that my time has now expired, and so if it grant me a little time to deal with this issue. The Republic of Yokum was left with, by the Confederation of Shangri's action, with no time to pursue any further means of pacific redress. Any opportunity which it had to deal with this matter by seeking arbitration, perhaps by this court, or indeed by resorting to any of the other peaceful settlement means referred to in Article 33 of the United Nations Charter, had been eliminated by Shangri's Act, which left no time for these matters to be taken into account.
What do you mean by Shangri Act?
The Shangri action, Your Honour, of sending these individuals to a place where they were to be set free and where any later action could be of no effect, because it's of cold comfort to Yokum that it may pursue a claim against SARC, when in fact these individuals have already been set free and they've already been perpetrating acts of further violence against Yokum and against its nationals. It's simply too late at that stage, and Shangri cannot argue that Yokum ought to have taken specific means of redress, when in fact it was Shangri's action which denied Yokum the possibility of pursuing such specific means.
Well, as far as I understand, we don't know about the Yokum doesn't know about the contents of the diplomatic note of SAC concerning the extradition. And there were 4 more hijackers who were in the Confederation of Shangri left. Why didn't you try to use some other peaceful means?
Well, Your Excellency, it's of little value to ensure that only 4 are punished if 3 go free in order to continue their acts. And while Yokum may not have been necessarily aware of the contents of SARC's diplomatic note, it was well aware of SARC's public statements to the effect that it intended the extradition of these people merely in order to set them free. And thus Yokum was understanding the realities of the situation.
I'm sorry, why didn't you then try by diplomatic channels to establish what are the real reasons behind the request for extradition from SAC?
Until, in fact, the aircraft took off, Your Honour, there was no reason for the Republic of Yokum to suggest or to believe that Shangri would not fulfil its obligations. Up until that stage, it had been maintaining these individuals in custody, and Yokum was entitled to expect that they would either be tried by Shangri or extradited to Yokum, or indeed some other state which was prepared to exercise jurisdiction over them. It was only once these individuals were sent on a plane to SARC that Yokum had the opportunity to be sure that Shangri had no intention of fulfilling its obligations in international law. And in fact...
But by your act, you put in danger the passengers and the crew of the whole plane. And you made although you intercepted that plane in the international airspace, you just stormed that plane in the third place, in the third state. It was actually, to some extent, can you consider it as an act of aggression, I guess, in the third state? Is it so?
Well, there's no evidence, Your Excellency, that the third state either agreed or disagreed with the actions that Yokum took on its territory. It can be implied, perhaps, however, that since Yokum troops were able to conduct an operation on the airport of Baylan with no apparent disturbance, that it can perhaps be implied that Baylan was acceding to the action taken by Yokum in this regard. But nonetheless, Yokum's action in diverting the aircraft was justified because one must balance, in terms of deciding whether the action was proportional as a response, one must balance the dangers in allowing this action to continue, the dangers that were clear to Yokum nationals from these individuals' publicly stated desire to continue their campaign of violence for as long as was necessary in their view, against the limited danger which existed to the crew and the 3 hijackers on board the aircraft. And I distinguish this case from civilian aircraft, where, for example, in the diversion of the Achille Lauro hijackers and the aircraft which was carrying them, that was actually a civilian airliner carrying other passengers, which is not the case here. And yet the international community failed to condemn such an action, and indeed states as diverse as Geoffrey Howe, Foreign Secretary of Great Britain, and indeed the TASS news agency of the Soviet Union indicated their support for the view that these hijackers ought to be brought to justice and that the American attitude was an appropriate one and a just one.
What happened in the hijacking case, interception case between between Israel and Egypt?
Between Israel and Egypt or Lebanon?
In 1886 case.
In that case, Your Honour, I believe that it was a Lebanese jet. I'm stand corrected by Your Honour if that's not correct. In fact, the Security Council failed to condemn such an action. The principal basis upon which it was complained of in the Security Council was as much that, in fact, the Israelis had made a mistake and the individuals that they thought were not on board, as the fact that the aircraft was diverted at all. And if one contrasts that position where the United States exercised its veto, and indeed 4 other states on the Security Council did not vote in favour of the resolution to condemn the hijacking, that one can argue that in fact this illustrates that there is not a universal principle of customary international law saying that a state may not divert an aircraft in such circumstances.
Now, what is your interpretation of Article 2, Paragraph 4 of the UN Charter?
Well, Article 2, Paragraph 4 prohibits the use of force not entirely, but in 3 specific circumstances which it sets out. That is a use of force which is in violation of territorial sovereignty, which there is certainly no example, no instance of violation of territorial sovereignty in this case.
Because it's not a sovereignty.
It's not a portion of territory sufficient for a state to declare that interference with it is an interference with territorial integrity. Territory is provided for jurisdictional purposes only by the aircraft conventions, but it certainly is not intending to make this an actual portion of Shangri's territory for the purposes of Article 2.4. The other leg of Article 2.4 is that the political independence test. But an action cannot form a part of a state's political independence if, in fact, it is illegal. And the basis of my argument has been that the action of Shangri in sending this aircraft to SARC was an illegal action and international law, and thus not falling within the scope of its sovereignty, and thus it was not an act which it could allege a political independent right to perform. And the final catch-all phrase of the Article 2.4 is that it should not be otherwise inconsistent with the purposes of the United Nations Charter. And that is perhaps the cornerstone of this entire issue. That in fact, the principles of the United Nations Charter are the maintenance of peace and security. And the maintenance of peace and security are certainly served in this instance not by allowing 3 dangerous international criminals to go free to continue their acts, but by a limited and appropriate use of force which restrained that, and which ultimately led to the position we now have, where these individuals are in custody and are able to be tried. Accordingly, the principles and purposes of the United Nations have been upheld in this very instance, and Article 2.4 has not been breached in any way.
Just to follow your argument, do I understand correctly then you are saying the legal basis for your interception lies because Article 2.4 has not expressly prohibited the interception or the similar acts of that nature?
It's argued, Your Honour, that because Article 2.4 prohibits the use of force in specific circumstances, that the use of force in other circumstances is governed by the customary international law which existed before the Charter came into place, and that includes the right to take action either by way of anticipatory self-defence, or indeed of reprisal, if one follows an Alila arbitration example. And therefore
the existing customary international law before the Charter continued to exist even after the Charter. The Charter does not change any customary international law.
Certainly the Charter changes customary international law, Your Honour, but only to the extent of its terms. And my argument is that the Charter does not establish a blanket prohibition on the use of force. And if in fact it had wished to do so, then the wording would have been very simple. But in fact it did not do so. It prohibited the use of force in terms of Article 2.4 in very specific circumstances. And therefore I argue that in any other circumstances, the customary international law which existed beforehand and as it has been modified since, still prevails. Accordingly, one must read Article 2.4 as it specifically is worded. And indeed that is the intention of the drafters. It would be a clear understanding of Article 2.4 and its reference to the purposes of the United Nations, that in fact it accepts and contemplates that there may be a use of force which might promote the principles of the United Nations, and its wording suggests that such a use of force is not prohibited by the Charter.
So you would accept such notions such as self-help or anticipatory attacks?
Certainly those which in this circumstances I've argued do not fall within the prohibition of the Charter. so that self-help which was in violation of territorial integrity or political independence might be a violation, but for example in relation to the Entebbe incident, where it was argued by Professor Julia Stone and others that it did not amount to an interference with sovereignty, certainly with territorial integrity, to make a temporary incursion onto a Ugandan airport for the purposes that were otherwise legal in international law. In such circumstances where Article 2.4 has not been breached, yes, Yokum does argue that the use of force is still permissible.
At its root, Mr. Agent, I find this to be a profoundly troubling argument because what it says is that, as I understand your argument, if in the unilateral opinion of any single state, the international dispute resolution mechanisms won't work quickly within the time frame set by the applicant state, then, except for some minor cases, unilateral self-help actions are perfectly acceptable. In this case, there was no resort to the General Assembly or to the Security Council. There was no application to the court for an interim order for relief. There were, in fact, as my brothers have pointed out, only a couple of attempts by Yokum to peacefully address this. Rather, what Yokum did was to take the law into its own hands and to say that because it felt that within a certain time frame we needed relief, we will cast aside international dispute resolution because in our opinion it's necessary. Isn't that really what your argument is?
Not quite, Your Honour, because what we are arguing is that the time frame was not set by Yokum, but it was set by Shangri, because it was Shangri which sent the aircraft to Sark, leaving no further moment for deliberation. Yokum had no reason to believe that its earlier attempts at pacific settlement of this dispute had failed. It had made requests of the Confederation of Shangri and had no reason, up until this plane departed, to suspect that those would not be fulfilled, and accordingly there was no dispute which at that time could be settled. And it took all of the means that were appropriate in the circumstances.
But Mr. Agent, the Texas cattle claims case which you mentioned earlier, those disputes, some of them lasted 60 years. The United States did not intervene militarily against Mexico. It did not actively intervene to protect its own interests in a case of ongoing raids. Rather, it pursued a peaceful resolution dispute. It seems to me that you're asking for it both ways here.
Not entirely, Your Honour, because raids which are engaged in a cattle rustling operation are quite different at international law, surely, from raids which involve the taking of lives of nationals of a state and which demonstrate a future intention to continue, if necessary, taking the lives of the nationals of those states, of that state. Accordingly, under the doctrine of an accumulation of events, argued by, for example, Professors Greenwood and Stoisser and others, that one is entitled to view this as an attack on Yokum's sovereignty and of a much greater and more significant magnitude than the mere interference with property rights over cattle. And accordingly, Yokum is entitled, in defence of its citizens and indeed in defence of itself, to take action where no other course is available to it. And once again, I refer the court to the fundamental issue that it was Shangri's action which denied Yokum the opportunity to take any further courses of action. It was Shangri's action in this case which has fundamentally interfered with the peace and security of the world order by attempting to set free terrorists. Yokum's action was appropriate, it was measured, and it was limited to the very threat that was posed. Accordingly, Yokum's action must be regarded by this court as legitimate at international law.
Could you also address the point about that the abduction of the 3 PACM members? Can you cite some legal basis to justify your abduction of the PACM members?
Certainly, Your Honour. Of course, Yokum, like all other states which are parties to the Hostages Convention, have an obligation under that convention to bring into its territory those individuals who have committed crimes under the Hostages Convention. And I refer Your Honour to Article 6 of that convention, and indeed to the general degree of support in the world community from numerous resolutions of the General Assembly, which one can look to because they've been passed over such a considerable period of time, and because, in particular, the resolutions which have been passed every couple of years relating to the suppression of terrorism by states, most recently in December 1987 by the Sixth Committee of the United Nations, that in fact there was a duty upon Yokum to ensure that these people were brought to justice, that duty was clearly not going to be fulfilled by Shangri in a purported extradition to SARC, which was to set these individuals free. Accordingly, Yokum was not only allowed but obliged by international law to ensure that these people were brought to justice.
Are you saying these resolutions are binding, or they are merely of persuasive power?
They are certainly of great persuasive power, Your Honour, and I'd refer Your Honour to the court to this court's decision in the Nicaragua case, where it said that the United Nations General Assembly resolutions were passed by an overwhelming majority and were passed in similar form over a considerable period of time and dealing with important issues, and may be regarded as perhaps the best evidence of declaring customary international law. And it is on that basis that I rely on them in this court, Your Excellency, not because they are binding on the court, but because they provide, as this court itself has said, the best evidence of customary international law on the subject.
How many resolutions are there on terrorism?
Well, I'm aware, Your Honour, of at least 7 passed in identical terms, going back as far as I think 1950, dealing with the issue of terrorism. And if one refers to the memorial, one can see that the most recent of these, as I said, was December 1987. The one before that was in the 42nd session, in the 40th session. I forget the resolution number, Your Excellency, but a series of resolutions, all of which, interestingly, have had the same title, which is Measures to Suppress International Terrorism and to deal with the underlying causes of terrorism, and it goes on for somewhat more than I'm unable to remember at the moment.
Submitting to the court that these resolutions are of the same, dealing with the same issues that we are talking about.
They are, Your Honour, because they deal with the requirement upon states to take action against terrorism, to bring terrorists to justice, and not to allow terrorists to conduct operations from their territory. And it's admitted that in referring to terrorists in this context, well, what the Sixth Committee is doing is referring to individuals who are doing exactly what PACM is doing, and that is conducting their activities not against their targets, but against civilian populations for the purposes of instilling fear in those populations in order to achieve some end.
I'm sure our colleagues all appreciate your immediate response, although according to the custom of International Court of Justice, you will be given the questions and you can answer tomorrow. Thank you.
I think my time has very seriously expired, Your Honour.
I think we have the drift of your argument, so thank you very much, Mr. Agent. Can I ask the bailiff how much additional time we've accumulated on this round? Not as bad as the court itself.
May it please the court, my name is Tan Soon Meng, and I appear as agent for the respondent state of Shangri. My co-agent is Ms. Lina Gan, and of counsel is Ms. Joan Francis. With the court's leave, we would at this time like to reserve 2 minutes of our time for Sir rebuttal. Your Excellencies, we've divided the circumstances of the case into 4 issues and in chronological order. The first issue relates to Shangri's obligations concerning the PACM's use of its territory as a base. The second issue relates to Shangri's attempt to extradite the first 3 PACM members to SARC. The third issue addresses Yokum's interception and diversion of the Shangri aircraft, while the fourth issue relates to Shangri's grant of asylum of the 4 remaining terrorists in response to Yokum's interception. I will be dealing with the first 2 issues, while my co-agent will address this court on the second 2 issues. Moving into the first issue then, Your Excellencies, the issue is whether Shangri is responsible to Yokum for failing to prevent attacks on Yokum nationals outside Shangri by PACM members using Shangri territory as a base. Before I continue on issue 1, Your Excellencies, I would like to make clear 2 points. The first is that on the facts, we submit that there is no indication of any connection whatsoever between the PACM and the Shangri government. We submit this on the basis that in the clarifications, it is clearly stated that Shangri, for example, does not recognize the PACM as a government in exile. We submit that the only issue before this court relates to a failure on Shangri's part to prevent PACM's use of its territory as a base. The second point I'd like to make clear is that it seems clear from the facts that attacks took place only outside Shangri. I bring this up only because in the declaration sought by Yokum, they state that there were attacks on Yokum nationals both in Shangri and elsewhere. We will argue our case on the basis that attacks took place only outside Shangri because on page 3 of the compromise it seems clear that that was the case. Our position on the first issue then, Your Excellencies, is that Shangri has not violated minimum standards of state responsibility by allowing the use of its territory as a base, and we ask for a declaration to that effect. Our position is based on 2 submissions. The first submission is that in customary international law, there is no obligation upon a state to prevent the use of its territory as a base. Our second submission is in the alternative, that even if such a duty were to exist in customary international law, Shangri has not breached its obligations because it has not failed to exercise due diligence in the circumstances of the incident case. Moving into my first submission then, for there to be a duty, Your Excellencies, in customary international law upon a state to prevent the use of its territory as a base, there must be shown to be constant and uniform state practice coupled with opinio juris. The burden is upon the applicants to show that there is such constant and uniform state practice and opinio juris. Our submission is that they have not been able to do so. They have cited 2 cases, and I would like to look at those 2 cases together with this court. The first is the Trail Smelter arbitration. We would submit that the Trail Smelter arbitration is irrelevant in considering the facts of the instant case, because there it could be considered a case of complicity. There, the Canadian government admitted liability for the damage caused to the United States environment, and the question was really on damages, for example. There, it is not the same as the incident case, where it is a question of a duty to prevent and not one of complicity. The second case that the applicants have strongly relied on is the Texas cattle claims. We would accept that this is a very powerful source of law. However, perhaps I would direct this court's attention to the exact words of the General Claims Commission in dealing with the activities of the Kickapoo Indians, and I would read, "The Mexican government not only failed to take reasonable measures to put an end to the crimes against a friendly neighboring state, but, and I emphasize, placed every obstacle in the attempt by the United States authorities to terminate the difficulty." Your Excellencies, surely the situation in the Texas cattle claims cannot be the same as that in the instant case, where we would submit the Shangri government did not place obstacles to prevent other states taking measures against the PACM, for example. The Texas cattle claims is a strong source of authority, but it does not support the applicant's case. Your Excellencies, however, understanding that this court may have some, difficulties with accepting that terrorists should be allowed to use a state's territory as a base, we would still submit that in the alternative, even if this court were to find that a rule in customary international law were to exist, based, for example, on those 2 authorities cited by the applicants, we would further submit that in any case, Shangri has not breached its obligation to exercise due diligence in the circumstances. Now,
Before you go to the second point, do you see a difference in terms of state responsibility in what you argue not to prevent your territory to be used, and to allow your territory in an implicit manner or tolerate it to be used for certain illegal purposes?
Yes, Your Excellency, we do see a difference. If, for example, a state would support passively the activities of a terrorist group on its territory. That is,
Support would be inactive, in my view, just tacitly tolerated without taking any action.
yes, Your Excellency. If a state,
Would you trying to argue on that point?
yes, Your
Thank you.
Excellency, if the state did not actively support the terrorists on its territory, I believe that's your concern. If they did not actively support the terrorists on their territory,
Just
but
did nothing.
yes, but in fact actually morally condoned their actions, we would submit that that state would be liable. However, that is not the case on the instant facts. We would submit that there is no evidence whatsoever that there is moral approbation on the part of the Shangri government for the activities of the PACM. Yes, Your Excellency.
Mr. Agent, you just said your counter-arguments against the two cases which were cited by the applicant. Can you cite any case in your favor?
Your Excellencies, I would not be able to cite, say, an arbitration that has taken place where a state has been held not to be liable for failing to prevent the use of its territory as a base. There does not seem to have been any arbitration with respect to terrorists in this respect, Your Excellency. I apologize for that.
Mr. Agent,
Yes, Your Excellency.
with respect to my brother's question, if a state had a tax law requiring that all citizens pay a certain tax, and in fact, none of the citizens paid the tax, wouldn't that then be a policy supporting the non-payment of tax?
Your Excellency, perhaps you could explain that again. I did not really...
Having to do with the allowance of PACM to exist, to live, to continue to operate, however it will, within PACM, I'm not quite certain that I can agree with your proposition that that was not active assistance. And I'd like to know how that differs from, say, the Alabama claims arbitration.
Well, Your Excellency, if, for example, a state had the means at its disposal to prevent the use of its territory as a base by terrorists and did nothing, perhaps this court could take that as evidence of acquiescence of some form, that is, a sort of moral approbation. However, that would be different from the facts of the instant case, where, as I would argue in the alternative, Shangri did not have the means at its disposal to prevent the use of its territory as a base. And that is the substance of my alternative submission, Your Excellencies.
But then doesn't that raise the question that if Shangri could not enforce its own law, would you agree that if Shangri could enforce its law, that it should have taken action against PACM?
Well, Your Excellencies, our first position is that there is no duty upon the state to actively prevent. However, we would state that the Shangri government, if it had the means, would have tried to prevent the use of territory as a base, despite its lack of international obligation on that part.
Well, then couldn't we view Yokum's action as doing for Shangri what Shangri says it would have done if only it could have done?
With respect to the interception, Your Excellency?
Or the prosecution of the alleged hijackers?
Well, Your Excellencies, we would submit that here, Yokum is attempting to place responsibility upon Shangri for not taking measures to prevent the use of its territory as a base, and that really is the question here. And we would submit that in the alternative, that even if there were such an obligation, Your Excellencies, and I believe that is the tenor of your concern, that even if there were an obligation, Shangri would not be liable because of the circumstances. And we must look at the circumstances of the case. Here, Shangri is a small developing country. Two religious groups are struggling for political control of the state and are involved in an armed conflict. This conflict has shattered Shangri's economy. The facts are clear. It states that Shangri, all of it, is in a state of near anarchy, and it is the confusion caused that has allowed the PACM to operate relatively undisturbed. We would submit, Your Excellencies, that on a reasonable inference from these facts, Shangri cannot be held responsible because it was both politically and economically unable to prevent the use of its territory as a base. Your Excellencies, if I may summarize on issue 1. Yes? Our position on issue 1 then is, first of all, there is no constant and uniform state practice to place an obligation upon a state to prevent the use of its territory as a base. In the alternative, even if such an obligation were to exist, Shangri has not breached its obligations because it has not failed to exercise due diligence in the circumstances. And the circumstances are that Shangri is in a state of near anarchy.
Can I ask you a question in that connection? Then you are saying that, in fact, you are not responsible for not keeping your country in order. And whatever happens is just too bad. There's nothing to do with you. You're not in position to take any action. You're not responsible.
Well,
what is then is the term of state that you are governing? You are the governing state of Shangri. What is the meaning of that? Don't you open a door that anyone can use that kind of argument trying to argue out of a case? And don't you think in this case there is some negligence on your part that you have, although it may not be? Would you elaborate on that?
Yes, Your Excellencies, we would submit first of all that this could not be used if the court were to judge in this case that Shangri is not liable. Other states would not be able to rely on it as an excuse for ignoring their state responsibility. The reason is because the circumstances of the case must be looked at, and they must clearly show that a state lacked the means to prevent use of its territory as a base before there can be liability upon that state.
You have authority for that.
You're
making a statement, right?
Yes, Your Excellency. Your Excellency, our position would be that if there is a rule of customary international law at all, then it must be based on, for example, the authorities cited by the applicants. And the Texas Cattle Claims itself then makes clear that a state is only under a responsibility to take all reasonable measures. Our position would be that in the instant case, because of lack of effective control and because of the political and economic climate of Shangri, it could not take the means. Yes, Your Excellency.
Someone argued that since your state is being recognized, therefore automatically assumes you have the responsibility.
Your Excellency.
That's the assumptions of recognition of states. You are recognized as the legitimate government.
Yes, Your
Then
Excellency.
the responsibility goes together with your rights as well.
Your Excellency, if this court were to uphold that proposition, that would mean that there would be a strict liability upon states to prevent use of its territory as a base, even in cases where it would be eminently unfair to do so, considering that they lack the means.
I hope you don't mean strict liability in the private law sense. Here we're talking about state responsibility.
Yes, Your Excellency.
I think there is a difference between the two.
Your Excellency, we would submit that even with respect to a state, all the facts must be looked at, and the responsibility upon that state is only one to exercise due diligence, as I mentioned, stated in the Texas Cattle Claims itself.
And you have no negligence in this case.
Your Excellencies, our position is that the Shangri government did not act negligently. Your Excellencies, considering...
This is a profoundly troubling proposition you're putting
Your
forward.
Excellency.
Is not another analogy, perhaps, is in state responsibility is the treatment of nationals of other states in your territory, and is not the unanimous holding of arbitral tribunals contrary to your proposition, and that is, say, in the U.S.-Mexican arbitrations with respect to state responsibility for the treatment of aliens, that it didn't matter if Mexico, in those cases, could live up to that minimum standard. That, in fact, they were liable because, as a state, they had a responsibility without exception. And isn't that really the current trend of the law today?
Your Excellency, we would submit that in the cases of injuries to aliens in one a state's territory, yes, we would admit that there is a clear liability on a state then to prevent the injuries to those aliens. However, this is a slightly different case. There is no evidence that any attacks on Yokum nationals took place within Shangri territory. Rather, it was merely a preparation for attacks outside Shangri, within Shangri territory. And we would distinguish those cases on that basis. Your Excellencies, perhaps considering my time, perhaps I may be allowed to move on to the second issue? Or would you like me to pursue? Thank you, Your Excellencies. Your Excellencies, we would accept on the second issue that the 1979 Hostages Convention is the regime under which the present case will be decided. On the facts, Article 1 of the Hostages Convention has been satisfied, as argued by the applicants, and an act of hostage-taking has taken place. We would then accept that Shangri's obligations under international law based on the Hostages Convention have been triggered. On the facts, however, Shangri has shown its...
Can you just 1 minute?
Yes, Your Excellency.
You accept the hostage convention is applicable?
Yes, Your Excellency.
Right. Now please tell the court at what exact moment that the convention became applicable.
Well, Your Excellencies, there may be one of 3 points at which the convention became applicable. That at first at the original seizure, or second, at the time the captain was threatened with death, or at the third possible time where the hostages upon the ship were detained so that the Shangri government could be compelled to grant asylum. It could have occurred at any of these 3 points.
Which one of these 3, in your view, is the exact point of application?
Your Excellencies, our position would be that in any case, whichever applied, the act of hostage-taking would have taken place. Would you like me to expand on that, Your Excellency?
No.
Thank you, Your Excellency.
I would be delighted if you could specify what your view of which one of the 3 points.
Well, Your Excellencies.
In your view, is a better argument in the light of the definition under the Hostage Convention.
Yes, Your Excellencies. In light of the definition under the Hostages Convention, we would submit that the clearest example of an act of hostage-taking would begin at the point of detention where there was a request for asylum from the Shangri government, because there would be a detention and a threat to kill the hostages in order to compel a third party, that is Shangri, to do something, and in that case, to grant asylum as an implicit condition for the release of the hostages.
Please.
Thank you, Your Excellencies. Your Excellency.
Maybe you could bring the microphone closer to you.
Your Excellencies, we would submit that the crux of the issue on this second issue is really on Article 8 and whether the extradition or the attempted extradition to SAC was a valid one. Our position is that by acting to send the 3 PACM members to SAC, Shangri acted in accordance with Article 8 that requires a state in which the alleged offender is found to do one of 2 things, to either extradite or to submit the case to its competent authorities for prosecution. The applicants have raised 3 reasons why they think that the extradition is not valid. They cite, for example, lack of jurisdiction of SAC, the fact that SAC is not a party, and third of all, that Shangri had notice of the statements made by the Shangri President and Minister of Justice. We would deny all 3 grounds, Your Excellencies. As His Excellency has himself pointed out, on the facts, there may very well have been SAC nationals aboard the Hasdrubal, considering that, after all, the last port of call was in SAC itself. On the second point of whether SAC is a party, I would direct this court's attention to page 5 of the compromise, where it is stated clearly that the SAC foreign minister sent a similar diplomatic note, similar meaning to the one sent by Yokum, considering that the Yokum note quoted both the 1949 Geneva Conventions and the 1979 Conventions. We would submit that on a reasonable inference of the facts, this must have been done by SAC, and surely only a party to the 1979 Conventions would have quoted it in a diplomatic note.
Mr. Agent, tell me please why you didn't claim in any way that you are going to prosecute these hijackers. You did arrest them the other day, but there were no answer about your intentions, about your plans, as if you were waiting for some request for extradition or for something else.
Your Excellencies, considering that my time is up, may I have an extent? Thank you, Your Excellencies. Your Excellencies, unfortunately, I have no instructions on the matter of why Shangri decided not to prosecute, or rather submit the case to prosecution within its own territory. However, we would submit that it is not inconceivable that because of the nature of the conflict within Shangri, that the Shangri government would rather extradite rather than submit the case to its own competent authorities.
Would you get your instructions if we delay your answer till tomorrow?
Your Excellencies, I could very well try. Your Excellencies, to determine if the extradition is a valid one, it's necessary to look to the facts. And on the facts, Shangri obtained 2 diplomatic notes, one from Yokum and one from SAC. We would submit that then the extradition to SAC was a valid one under Article 8 of the Convention.
Mr. Agent, there are really 2 things here. First, agent for the applicant argued that there is a question of the intent of SAC. And we know from the Vienna Convention on the Law of Treaties that there's an obligation of good faith. What of that argument?
Your Excellencies, the applicants have based their case on the fact that the Shangri government had notice of SAC's intention. However, on a closer reading of the compromise, Your Excellencies, it will be revealed that there is no evidence whatsoever that the officials from Shangri that took the decision to extradite to SAC had any notice of the news media statement whatsoever. The applicants based their case entirely on an assumption, and we would submit that it cannot stand before this court.
If you knew of it, then what would be the result?
Yes. Your Excellencies, even if the Shangri government were to have known of the statements made by SAC in the news media, well, there would be 2 possible responses to it. The first is that in any case, the responsibility upon SAC as a party is only that under Article 8, to do one of 2 things, either to extradite or to submit the case to its competent authorities for prosecution. The words are very important, Your Excellencies, because what those words mean is that a state is not obliged to prosecute and punish alleged offenders. After all, they are alleged offenders to begin with.
Obligated to prosecute, not to punish.
Your Excellencies, I would submit that it is not, yes. Your Excellencies, the second point I would make, that in any case, Shangri was entitled to rely on the official processes followed, that is the diplomatic note, and the fact that SAC is a party to the 1979 Hostages Convention, and rather not on a news media statement made by politicians. We would submit that our actions were thus in good faith, complying with Article 31 of the Vienna Convention and in compliance with customary international law. Your Excellencies, considering that my time has been up for some time, would you like me to summarize, or should I ask my co-agent to continue?
I'd like to ask you another point which was not mentioned in your brief or in your presentation. That is, does the Law of the Sea Conventions, both the 58 and 82, applicable in the present case? Are they piracy within the meaning of the relevant provisions in the conventions?
Well, Your Excellencies, the relevant provisions we would submit would be either Article 15 of the 1958 Conventions on the High Seas or Article 101 of the 1982 Convention on the Law of the Sea. We would submit that neither of the articles, well, in fact, they're identical, neither of the articles would apply on the instant facts, because clearly what was envisioned was a 2-ship affair, where a private ship would intercept another ship. And in addition, the interception must have been for private ends. We submit, first of all, that 1, this was not a 2-ship affair, and second, that there were no private ends concerned. Your Excellencies, if I may summarize.
One more question concerning the extradition. Thank you so much. Concerning that extradition, why you decided so swiftly with regard to the diplomatic note from SAC? You know that there were more nationalities on that ship, and even 2 from Belgium were killed. So you quite could expect that Belgium would ask for extradition too for these hijackers to be punished.
Your Excellencies, we would submit that with respect to whether we should have waited for Beilan to make a request, Shangri, being in the state in which it is, we would submit that it wanted to try to extradite as quickly as possible these 3 PACM members, rather than to have to deal with them in its own territory. And in any case, if a state decides to extradite under Article 8, there is no, say, list of priorities that it must follow, and consider, say, that Yokum had more nationals on board the ship than SAC did, Your Excellency, and that Yokum would have been entitled to extradite to either Yokum or SAC.
If the court were satisfied that SAC intended not to try the hijackers, but in fact to set them free, and if the court were satisfied that Shangri, the government of Shangri, knew of that intention, then what would be the effect here?
Your Excellencies, if it was very clear on the facts that the SAC government was going to release these 3 PACM members, and the Shangri government had been in connivance with the SAC government to release them, we would accept liability, Your Excellencies. Your Excellency.
And you submit that on the basis of the facts as set out in the compromise, there is no such evidence to support that, your last statement?
Yes, Your Excellencies, especially since the burden of proof is on the applicants to prove their case. Your Excellencies, would you like me merely to conclude and pass on to Ms. Gan, or should I summarize?
One more question concerning that extradition. I'm sorry for insisting on that, but there is one more thing.
Yes, Your Excellency.
In the diplomatic note from SAC, there was a request for extradition for all hijackers. You decided to extradite only 3.
Yes, Your Excellency.
What is the reasons behind it?
Your Excellencies, it is not clear on the facts why Shangri decided to send the first 3 PACM members to SAC. Perhaps the remaining 4 would have been sent to SAC on a later flight. We do not know, Your Excellencies, and unfortunately, I don't have instructions on the matter. But again, I could perhaps find out by tomorrow.
Well, the time for clarifications is long since passed. I think we have the drift of your argument. Thank you, Mr. Agent.
So I'll hand the floor over to Ms. Gan, Your Excellencies. Thank you, Your Excellencies.
May it please the Court, my name is Lena Gan, and I appear as agent for the respondent, the Confederation of Shangri. I shall be dealing with the remaining 2 issues, which appear as issues 3 and 4 in the respondent's memorial. Issue 3 is whether Yokum is internationally responsible for forcibly intercepting the Shangri aircraft and abducting persons on board. The 4th issue is whether Shangri's grant of asylum to the remaining 4 PACM members was a lawful response to Yokum's forcible interception. With respect to the 3rd issue, it is Shangri's position that Yokum is internationally responsible for forcibly intercepting the Shangri aircraft and abducting persons on board. We seek a declaration to this effect and further pray this Court to order Yokum to return the individuals who were abducted. In support of our position, I shall be making 3 main submissions. First, that Yokum's actions violated the Charter of the United Nations. Secondly, that their actions interfered with our freedom of overflight over the high seas. And finally, that Yokum's actions may not be justified, either as an act of self-defense or as an act of reprisal. Your Excellencies, international relations today are predicated upon sovereign equality of states and upon mutual respect. As a testament to this, the Charter is upheld by 2 fundamental principles: the prohibition against the use of force and a peaceful settlement of disputes. The prohibition against the use of force is set out in Article 2, Paragraph 4 of the Charter. It is our submission that Yokum's actions, by sending up fighter jets to intercept a defenseless aircraft over international waters, was a breach of this article. This is because Yokum's actions was a threat or use of force against the political independence of Shangri, and it was also a threat or use of force inconsistent with the purposes of the Charter. The political independence of a state includes both its internal and external sovereignty. It includes its ability to conduct relations with other states and its ability to fulfill its international obligations. By intercepting our aircraft and abducting persons on board, Yokum interfered with our lawful response to SAC's extradition request, and it prevented Shangri from fulfilling our treaty obligation to try or extradite the 3 PACM members. Yokum's actions were also inconsistent with the purposes of the Charter. The primary purpose of the Charter is the maintenance of international peace and security. This is clearly set out in Article 1, Paragraph 1, which further emphasizes that international peace and security is to be achieved by the peaceful settlement of international disputes. This fundamental principle is reiterated in Article 2. Yes, Your Excellency.
Excuse me, before you go into the peaceful settlement of disputes, you have heard the agent for Yokum who had argued when I questioned him in relation to Article 2.4, his argument. Would you like to address some of the points that he had specifically mentioned and the counter-arguments? Thank you.
Your Excellency, I believe that the agent for Yokum has submitted that their actions was not a breach of Article 2.4 because it did not violate the territorial integrity or political independence of Shangri. However, Your Excellencies, it is our position that our political independence has been interfered with. Yokum is not in a position to say that our extradition to SAC was an unlawful response and therefore to use force unilaterally against Shangri. Your Excellencies, every state must be given the right to make its own decisions in its relations with other states, and we have done so. We have fulfilled our treaty obligation to try or extradite these 3 PACM members. Your Excellencies, it is our submission that Yokum's actions was against the political independence of our state, and further, it was inconsistent with the purposes of the Charter.
I remember the agent specifically refers to the fact that there is a gap in Article 2.4, if I remember correctly, that gap permit them to take that action.
Your Excellency, I believe that the agent for Yokum was arguing on the basis that Article 2.4 is not a general prohibition against the use of force. Your Excellencies, for the purposes of oral argument, Shangri does not take the position that Article 2.4 is a general prohibition against the use of force. We would submit that if we can show that Yokum's actions violated any of the 3 limbs of Article 2.4, then Yokum would have used force against Shangri in breach of Article 2.4. And it is our case today, Your Excellencies, that Yokum indeed has violated 2 of those limbs. Namely, they have acted against our political independence, and they have acted inconsistently with the purposes of the Charter. Your Excellencies, Yokum did not resort to any of the available means which were open to them for peaceful settlement of this dispute. Their actions are particularly reprehensible because in the present case, Article 16 of the Hostages Convention clearly provides for dispute settlement. Instead, they ignored the proper procedures of international law, and they took the law into their own hands and intercepted our aircraft. Your Excellencies, it is Shangri's position that Yokum's actions clearly violated Article 2, Paragraph 4, as well as Article 2, Paragraph 3 of the Charter.
Sorry to interrupt you. According to the compromise, how long did Yokum had to before the interception took place, before they knew that the three alleged hijackers were on board bound for SAC?
Well, Your Excellency, it is not clear in the compromise specifically at which point in time Yokum knew that the 3 PACM members would be extradited to SAC and not to Yokum.
You think you could ask for instruction how long it might be?
Yes, Your Excellency, I'm sure I could by tomorrow as well.
For the time being, would you like to say how long was that?
Your Excellency, perhaps at the very latest, they would know that the 3 PACM members were not bound for Yokum but for SAC when the airplane actually took off in the direction of SAC. However, Your Excellency...
And you think there is time to start the settlement of dispute procedures?
Your Excellency, we would submit that if Yokum had felt that this extradition was in violation of the Hostages Convention, and indeed it is our submission that it was not a violation of the Hostages Convention, then they could have brought Shangri to arbitration under Article 16 of the Hostages Convention.
And the point isn't it that they heard the alleged hijackers were on board, then what do? That's the point you have to decide. Do you think it's reasonable to ask them to start the settlement of dispute procedure? I'm sure you're quite familiar with most recently on the newspaper the dispute between the United States and you and how long a settlement of dispute procedure takes.
Yes, Your Excellency.
And there is always the danger, the other side would argue there's no dispute.
Yes, Your Excellency. However, even if Yokum could not have brought Shangri to arbitration, we would submit that other alternative means were open to Yokum. when the PACM members landed in SAC, they could have asked SAC to extradite these members to Yokum. There is no indication that SAC would have refused such a request. And in any case, Yokum did not give SAC an opportunity to show that they would have fulfilled their international obligations under the Hostages Convention. Your Excellency, we would submit that it is not for Yokum to decide that both Shangri and SAC have failed to satisfy their obligations under the Hostages Convention. Your Excellencies, it is the respondent's submission that by forcibly intercepting our aircraft over international waters, Yokum used force against Shangri in breach of Article 2, Paragraph 4 of the Charter and in breach of Article 2, Paragraph 3 of the Charter. Now, Yokum has attempted to justify their actions as a mixture of self-defense and reprisal. We would, however, submit that this cannot be the case. With respect to self-defense, it is our position that any attacks which occurred on Yokum nationals or economic interests were carried out by the PACM and not by Shangri. Shangri did not support the PACM or connive with them in any way. As such, any right of self-defense which would have risen would have been with respect to the PACM and not with respect to Shangri. However, yes, Your Excellency.
But isn't there really, Article 2.4 we all can accept, it's very clear as far as it goes, but isn't there really a corollary of Article 2.4, and that is the question of state responsibility. If a state cannot threaten or use force against another state because of this rule which is enshrined in Article 2.4, the corollary must be that that state cannot allow others to strike out and use that state boundary as a veil. And isn't that really what's going on here?
Your Excellency, I should like to answer that in two stages. First, it is our submission that we have not breached any any customary international law obligation with respect to the use of our territory as a base for terrorist attacks.
But in fact, it's happening.
Well, yes, Your Excellency.
So then, it's on the one hand, you're establishing a veil and saying no violation of Article 2.4 against Shangri territorial political independence. That's clear. On the other hand, it's unfortunate that we're violating Article 2.4, or it is in fact being violated because terrorists are operating from our territory, and that's just the way it is.
Your Excellency, we would submit that Shangri's position, the situation at present, absolves Shangri because we are in a state of near anarchy. The whole of Shangri, Your Excellency, is in a state of political and economic chaos. It is not fair to expect Shangri to satisfy its customary international law obligations under such circumstances.
No, it goes beyond the customary international law. Presumably PACM has had some influence on the state of things within your country, and that might be an inference from the compromis. If that's the case, then perhaps that had an influence on the decision to extradite to SAC. And if that's the case, then why is there not a right on Yokum's part to intervene and say, let's put an end to this?
Your Excellency, it is our position that the Shangri government in no way supports or is influenced by the PACM. In fact, we would act against the PACM if we could. However, the circumstances show that we can't.
So there's a perfect equipoise. You don't influence them and they don't influence you, and you're just peacefully coexisting.
Well, Your Excellency, not exactly peacefully coexisting. However, we would submit that the PACM has no influence on our governmental decisions. Your Excellency, even if Shangri did breach any obligation which was owed to Yokum, we would submit that this does not give them a right of reprisal against us. This is because, first, reprisal may not involve the use of force, and Yokum's actions did in this case involve the use of force in breach of Article 2, Paragraph 4. Secondly, Your Excellencies, a reprisal must be proportionate, and we would submit that in the present circumstances, Yokum's actions were not proportionate to any breach of international obligation which we may have made. Now, Yokum has alleged that we have violated our obligations under the 1979 Hostages Convention. In response to that breach of a treaty obligation, they have, however, violated three separate aspects of international law. They have used force against us in contravention of Article 2, Paragraph 4 of the Charter. They have failed to settle the dispute peacefully in contravention of Article 2, Paragraph 3 of the Charter, and we would further submit that they have breached our freedom of overflight over the high seas. Your Excellencies, the freedom of overflight is a well-established rule. It is codified in both the 1958 Geneva Convention on the High Seas as well as the 1982 Law of the Sea Convention. There is no exception at international law which allows one state to intercept another state's aircraft for the purpose of arresting terrorists on board. If Yokum wishes to establish such an exception which justifies their actions, it is for them to show to this court clear and convincing evidence that there is constant and uniform state practice coupled with opinion juries which allows them to rely on such an exception.
In the Laurel case, was the United States condemned? What was the reaction of the international community after the interception?
Your Excellency, we would accept that the Laurel incident did receive some political approval. However, we would submit that it is precisely because they received this political approval that the Laurel incident opened the door to further abuse by other states. For example, Your Excellencies, after the Laurel incident, the Israelis felt emboldened to intercept a Libyan aircraft over international waters in 1986. This was widely condemned in the Security Council and indeed agent for the applicant.
Do you think the actor makes any difference in this case, or was you are talking the law has changed?
Your Excellency, we would submit that the law has not changed in this respect. The prevailing law remains that all states have a freedom of overflight over the high seas. Recent incidents do not establish any exception whatsoever to this.
Why then, after the Laurel interception, the international community did not voice any opposition to that effect?
Your Excellency, we would submit that perhaps it was politically expedient for the international community not to condemn the United States action. However, we would further point out to this court that the American interception in the Laurel incident was never justified legally, and indeed we would submit that there was no legal basis for its justification. Your Excellencies, it is our position that international law does not permit the interception of aircraft over the high seas for the purpose of arresting terrorists on board. And this was clearly reiterated by the Security Council in its condemnation of the Israeli action over the Libyan incident.
Isn't it the difference that if you caught the right person, it's all right, if it's the wrong one, it's too bad?
Your Excellency, we would submit that this is not the case. We would submit that at the very bottom line, international law remains, and it must govern this case. And international law clearly states that Yokum's actions violated our freedom of overflight and was a use of force against us. Your Excellencies, to some...
I have a question here, and this is really, I think, one of the fundamental propositions of the applicant, and I think it is a valid point, and that is the strict application of the law is well and fine, but in the circumstances of this case, what's happening? What if Shangri prevails? Then we would declare that the aircraft should never have been hijacked or diverted, as it were. That it may well be that SAC lets the terrorists go, and it's fairly apparent that since Shangri is not any more in a position to control the activities of PACM, that will continue, and that perhaps Yokum and other states will continue to be victim states of that activity. So what is it that we are achieving here? On the one hand, it seems that we're being asked to vindicate Article 2.4, but at the same time, it seems that we're being asked to perpetuate this sort of disorder.
Your Excellency, we would accept that terrorism is of very grave concern to the international community. However, Your Excellencies, there is another equally important concern, and that is that militarily powerful states cannot be allowed to think that they can coerce smaller states, for example by intercepting their aircraft, into taking actions which these militarily powerful states require them to do. Your Excellencies, if this court should find that Yokum's interception was valid at international law, they would be sending out such a clear signal to other militarily powerful states, and this would also contribute to international chaos. Your Excellencies, as my time is running out, may I be permitted to proceed to the final issue?
Madam Agent, can you tell us something about the state legal doctrine with regard to planes and ships registered in Shangri?
Your Excellency, planes and ships which are registered under Shangri bear the nationality of Shangri. However, it is not our argument that they are per se the territory of Shangri. With the court's leave...
You're moving to the fourth
final
question.
issue. Yes, Your
Final
Excellency.
issue. Maybe I should ask you some other questions here before you move to the final one. That is, what is your submission with regard to the applicability of the ICAO hijacking conventions, and also the applicability of the Law of the Sea Convention? Is the interception a piracy?
Your Excellency, with respect to the ICAO conventions, we would submit that they do not apply in the present case, because in none of these conventions do the definitions of the offenses fulfill the circumstances of the present case. With respect to the Law of the Sea Convention, we would submit that that is one of our sources of our basic international law, that there is freedom of overflight over the high seas. However, as my co-agent has submitted, it is our position that there has been no piracy in the present case, because this is not, the Hasdrubal incident was not a two-ship incident, and it was not committed for private ends.
The interception?
Oh, the interception, Your Excellency. We would submit that the interception was not piracy either, as this was not committed for the private ends of the individuals who intercepted the aircraft. Your Excellency, my time is up.
You can go on to your next item.
Thank you, Your Excellency. On the final issue, Shangri submits that our grant of asylum to the remaining 4 PACM members was a lawful response to Yokum's forcible interception. We seek a declaration to this effect. Your Excellencies, we accept that we are under an obligation to try or extradite the PACM members under the 1979 Hostages Convention, and we further accept that our grant of asylum is a prima facie breach of this obligation. However, we would submit that our grant of asylum may be justified as a lawful countermeasure. Your Excellencies, international law provides that a countermeasure may be taken if 3 elements are satisfied. First, that the countermeasure is justified. Secondly, that the countermeasure is proportionate. And thirdly, that it follows an unsatisfied demand. In the present...
Where do you derive the legal... What is the legal basis of this countermeasure?
Your Excellency, the legal basis of countermeasure is founded in the Nolila case, where these 3 elements were laid out, and it is further adopted by the International Law Commission in its draft articles on state responsibility, Article 30.
What is the legal status of ICJ draft articles?
Your Excellency, we would submit that they provide the best evidence of what is currently international law, as they have studied all the previous primary sources and have put them together into a set of draft articles concerning state responsibility.
Are countermeasures permissible under Article 2.4 in your view?
Your Excellency, it is our position that any breach of Article 2.4 may not be justified as a countermeasure. However, quite apart from that, international law does recognize the right of a state to resort to countermeasures. Yes?
But in the Nolila case, the arbitration between Portugal and Germany, that was a reprisal.
Yes,
I mean,
yes,
we've
yes.
just called it a countermeasure, but it was a reprisal. It was a method of self-help. And I think what my brother was getting at was the question of how is this different from Yokum's self-help? And how is one justified and not another? And how does that relate to the current interpretations of Article 2.4, which would seem to conflict with the holding of the Nolila case?
Your Excellencies, it is Shangri's position that countermeasures under international law are the same as reprisals. They are just another term which encompass what were previously known as reprisals under international law. However, with respect to the Norlila case, we would submit that it is still valid authority where the three elements of a reprisal or a countermeasure are concerned. However, it is no longer authority that an armed reprisal may be taken by a state. Your Excellencies, we would submit that international law as it stands presently does not permit the use of force to be justified as a countermeasure or reprisal, and this is clearly stated in the 1970 declaration by the General Assembly, where it is stated that states may not resort to reprisals involving the use of force. Your Excellencies, we would...
In fact, you are using a reprisal as your legal basis.
Yes, Your Excellency, a reprisal, otherwise known as a countermeasure under the International Law Commission's draft articles.
And is it still compatible in your view with the Declaration on Friendly Relations?
Your Excellency, we would submit that it is, because our reprisal does not involve the use of force. Your Excellencies, we merely breached our treaty obligation under the Hostages Convention, and we would submit that this is a proportionate response to what Yokum did. Yokum forcibly intercepted our aircraft. They used force against us, they ignored whatever proper procedures were available to them under international law, and they ignored our safety of flight over the high seas. In response, Your Excellency, we would submit that our grant of asylum was very proportionate to their breaches of international law. Further, Your Excellencies, we would submit that although in general an unsatisfied demand is required, this is not strictly necessary where it is inappropriate or futile under the circumstances, and we would submit that under the circumstances it was futile for Shangri to have made any demand upon the Yokum government. In view of the extreme lengths to which they went to take custody of the three PACM members, Your Excellencies, it is a reasonable conclusion that any demand that Shangri would have made would not have been answered.
But at the same time, aren't you guilty of very much the same thing, of not going to the court or to the General Assembly and pursuing your measures for redress for peaceful dispute, but rather that you did precisely now what you are accusing Yokum of doing, and that is taking things into your own hand. As you said, a prima facie instance of a violation of the treaty, really one of perhaps the fundamental purpose of the treaty, not a minor violation, a severe violation of the treaty. How are we to balance these? You know, on the one hand you say, oh yes, pursue it, and on the other hand say, but no, we don't have to. I mean, that seems to be the gist of your argument.
Your Excellencies, we would submit that there is a fundamental difference between Yokum's reprisal and ours. Yokum's reprisal involved the use of force, and as such, it cannot be allowed under international law, nor was it proportionate to our alleged breach of international law. Whereas, on the other hand, Your Excellencies, our grant of asylum did not involve the use of force. Your Excellencies, we would submit that under international law, a state is given the right to resort to reprisals or countermeasures as they are otherwise known. However,
doesn't state practice go the opposite way, and don't in fact states continue to use force in reprisal measures? And notwithstanding endless General Assembly resolutions which have been suggested here, is it not a fact of life that force is used? And is it really for this court to say that states haven't done it? I mean, aren't we to recognize the reality?
Your Excellency, we would submit that yes, indeed, force has been used in international relations. It cannot be avoided. However, when such force has been used, states have had a valid reason for it. And this derives from the defense or justification of self-defense, which is not open to Shangri under present circumstances.
Madam Agent, what about in the Persian Gulf the other day? Where was the self-defense element of that? We can go through hundreds of instances in the last few years of the use of force. Isn't it simply a fact that we haven't evolved to the point of your definition of countermeasures, of your distinction of force, and that the court really must say that force is not the key, the violation of the law is the key, and that both sides have violated the law.
Well, Your Excellency, firstly, we would submit that we have not violated the law by attempting to extradite the 3 PACM members to SARC. Secondly, we would submit that force is recognized, that it cannot be justified as a countermeasure. Your Excellency's Article 2.4 constitutes a peremptory norm, and as such, it is a fundamental principle from which there can be no derogation or modification, and a reprisal is an unacceptable and unrecognized modification or derogation of Article 2.4.
So the United States violated international law the other day in the Persian Gulf by blowing up 6 oil rigs of the Iranian government.
Your Excellency, unless they can justify that as self-defense, then yes, it would appear so.
But isn't it consistent with the practice of states and a body of customary law which sets out the norms that were merely being adhered to? I mean, where has the world community really condemned the United States? And if the world community doesn't, this court is not in the position of creating law, it's really in the position of interpreting the law, and part of that law is custom. And custom is a high source of law. Subsidiary sources are publicists.
Your Excellencies, we would submit that current state practice, or state practice ever since 1945, does not show that states unequivocally accept that use of force may be justified as a reprisal. Indeed, Your Excellencies, in 1970, the General Assembly, which consists of most of the nations of this world, clearly stated that reprisals may not involve the use of force, and we would submit that such General Assembly resolutions, which are adopted by consensus, are the best evidence of what customary international law is.
I'd like to go back to the one point you mentioned earlier. That is, you submitted that as a countermeasure, you released the PACM members. Now, on the one hand, you have admitted that the hostage conventions are applicable, and you have an obligation to prosecute. There's a clear obligation in that respect. Can you tell the court why did you choose to release the alleged the offenders as a countermeasure instead of choose some other matters as a countermeasure? Is my question clear?
Yes, Your Excellency. We would submit that the release of these 4 PACM members was an appropriate countermeasure to take, because it would have shown to Yokum that they cannot enforce or force upon their opinions, upon Shangri, as to their interpretation of the Hostages Convention.
Isn't at the same time you have no doubt violated the convention yourself? Had you choose other economic measures, for example, that may have given you a better excuse, would not?
Your Excellency, we accept and we do submit that countermeasures are prima facie unlawful. Therefore, we do accept that our grant of asylum was prima facie unlawful as it breached our obligations under the 1979 Hostages Convention. However, this is justified because of Yokum's prior internationally wrongful act against us. Indeed, there are 3 separate breaches of 3 separate rules of international law. Your Excellencies, if there are no further questions, may I just summarize the respondent's case?
Can you tell us, in your opinion, just maybe the last question, can you tell us, in your opinion, if another state violates the law, you're free to violate the law too?
I beg Your Excellency's pardon?
I mean that if another state violates its obligations, you are free to violate obligations too?
Your Excellency, international law recognizes that if one state violates its international obligations as against another state, then that other state may take a countermeasure or reprisal against this first state, and this countermeasure or reprisal may involve the violation of an international obligation.
That can be valid with regard to bilateral agreements, bilateral treaties, but not with regard to multilateral treaties. And convention hostage taking, just an example of that multilateral treatment. And if you disregard your obligations with regard to this convention, it means that you disregard your obligations with regard not only to Yokum, but to other states too.
Your Excellency, I should like to answer that in two steps. First, we are seeking to justify this act as a countermeasure only vis-à-vis Yokum. Therefore, our relief in this court is only vis-à-vis Yokum. Secondly, we are of the position that our breach of international obligations under this convention does not affect the interests of third states. Your Excellencies.
Sorry. Well, but when you set free these 4 hijackers, that means that you set them free and let them free hand to do whatever they want, to continue their course of liberation, to continue attacks on other states. That means that you acted not only against Yokum, but you have acted against all other states which are involved in this case, or if we say just in general terms, the case concerning the activities of PACM.
Your Excellencies, we would submit that the interests of third states, if they had been affected, would be brought to the notice of this court, because third states, under the statute of the International Court of Justice, have a right to request to intervene in the present proceedings. And we would submit that if other states, in particular Beilan or Mitbari, felt that their interests had been affected, they would have intervened. However, as the compromise clearly shows, they have not done so.
But they didn't have enough time to do it, because the events developed so quickly, so they didn't even have the time to prepare any, say, diplomatic notes or to prepare a request to you by diplomatic channels or by other channels to settle the whole matter. Because actually the release of these 4 hostages means that it is certain, say, negligence with regard to relations to these countries too.
Your Excellency, we would submit that third states would have had time to intervene in the present proceedings because under Article 40, all interested states are required to be given notice of any proceedings in the court which may affect their legal interests. Your Excellencies, may I be permitted to summarize and conclude on the respondent's case? Thank you, Your Excellencies. It is the respondent's case that we have acted lawfully and reasonably under the given circumstances, and we would pray this court to declare that Shangri is not internationally responsible for the use of our territory as a base for terrorist attacks, that Shangri is not internationally responsible for attempting to extradite 3 PACM members to SARC, that Yokum is internationally responsible for forcibly intercepting our aircraft, and finally, that we are justified in releasing the remaining 4 PACM members. Thank you, Your Excellencies.
I'd ask the bailiff how much time we've gone over this time. Do you care to exercise your right of rebuttal?
May it please the Court, Your Excellencies, I wish to respond to the 4 principal submissions made in the submissions of the respondent in this issue. The first submission in relation to state responsibility made by the respondent rested upon their principal submission in oral argument, that in fact they were under no duty whatsoever to prevent raids where those raids involved activities in states other than the state of Shangri, over which it had territorial control. I can only refer the Court to the arguments which have already been presented, but which are perhaps best encapsulated in the respondent's memorial, where it says at page 2, they admit that the duty, quote, extends to preventing the use of its territory as a base for attacks on foreign nationals in other states. And indeed it was conceded in that memorial that in fact there was such a duty. The only real issue before this court is whether that duty was fulfilled, and it's been argued already sufficiently that the duty was not fulfilled because Shangri had demonstrated that it had the capacity to deal with PACM, and that in fact it chose not to deal with them in any way whatsoever. The second submission was in relation to the duty to try or extradite the members of PACM. Counsel for Shangri relied on the fact that their purported extradition to SARC of 3 individuals was a fulfilment of this requirement. But it's already been argued before this court by Ms. Hudson that in fact this was not a valid extradition because it failed to be in good faith, that it was a sham. And I could refer the court further to Article 26 of the 1969 Vienna Convention on the Law of Treaties, which embodies the principle of pacta sunt servanda, that a state must exercise its obligations under a treaty in good faith. And it's clear that a state with notice of another state's intention not to perform its obligations can hardly be said to be performing its own obligations in good faith if it presumes the contrary to what it knows is likely to be the case. To move to the...
I'm sorry, Mr. Agent, but indeed law of this Convention of the Law of the Treaties, there is another position with regard to rebus sextantibus.
I'm sorry.
There is another provision concerning the rebus sextantibus situation. Can you develop on this?
I'm sorry, Your Excellency, I'm having difficulty understanding.
Rebus sextantibus, changing circumstances.
Yes, Your Excellency, sorry. I apologise for difficulties in understanding. The real point is, Your Excellency, is that circumstances had not changed by the time the extradition was made. That at the time that the extradition was made, Shangri was aware of all of the circumstances, and it's apparent, notwithstanding the argument placed by the respondents, that it would appear very unlikely that Shangri was unaware of the statements of the SARC Justice Minister and President, which were made over a week before it purported to extradite these individuals to SARC, when these were statements of the most high-ranking officials in a neighbouring state, which bore specifically on a matter of great importance to Shangri itself. It seems inconceivable that Shangri could have been unaware of these statements, and therefore circumstances had changed already by the time Shangri took its action. In relation to the other four individuals, which was in fact the fourth submission, if I may deal with them out of order, of the respondent, it was argued for the respondent that the grant of asylum to these individuals was justified as an act of retaliation for Yokum's having breached the Hostages Convention itself. Now, it's already been argued that Yokum in fact did not breach the Hostages Convention because under Article 16 of the Convention it had already exhausted the specific means that were available to it for a resolution of what dispute there was. However, nonetheless, even if one were to accept that there may be some basis for a retaliation, this is not an appropriate one because it involves the breach of a multilateral obligation, and it is inappropriate for Shangri merely to assert that because it's entitled to breach its obligation as against Yokum, that Yokum is not entitled to come before this court and suggest that that was nonetheless an illegal act because of its impingement upon third states. And it's, I suggest, appropriate for this court to consider the effect on those states in regarding the legality of the act, rather than necessarily merely presuming that a state needs to step into this court in order to uphold its interests. This court must look to the question of whether the act was a legal retaliation, and the interests of those states will be relevant to that, notwithstanding that they may not appear before this court. The third and the last, which I will deal with because I've already dealt with the fourth submission of the respondent, was in relation to the use of force, that this was a violation of the political independence of Shangri. But political independence is, of course, tempered by the fact that states must respect international law, that a state does not have the independence or the sovereignty to do acts which are in contravention of international law. Accordingly, it was not an exercise of the political independence of Shangri to send these individuals to a safe haven in contravention of its duties at customary international law and under the Hostages Convention to bring individuals who are guilty of international crimes to justice. And accordingly, Shangri cannot rely on the question of political independence in support of their proposition, nor can they rely on the related concept of freedom of overflight of the high seas. For this is analogous to saying that a man may walk down the street firing a gun at other people, and because he's able to rely on his right to walk down the street, that one can't prevent him firing the gun. The freedom of overflight is part and parcel of the whole flight of this Shangri aircraft, and the whole flight of this Shangri aircraft was an illegal act, and one can't separate the purpose from the substance. In relation to the submission about self-defence and reprisal, it need only be pointed out that in acts in the Gulf, for example, and my time has expired, if I could just briefly pursue this point, recent acts in the Gulf demonstrate that a proportionate action, which is limited in its scope, is appropriate and will not be condemned by the world community. This is clearly a proportionate action. The harm suffered by Shangri is limited, if any whatsoever. For what has been achieved is that 3 individuals have been brought to justice, and Shangri claims that that was their intention all along, and that Shangri has got its aircraft back intact. It has suffered no harm, and yet in retaliation to this, it seeks, in turn, to retaliate by setting free international terrorists to continue a terror regime against Yokum and other states. it is quite clear where the justice in this matter lies. It is quite clear who is the victim and who is the supporter of those who would use terrorist means in the threat of international peace and security. Accordingly, I feel confident this court will determine that Yokum's actions are appropriate and a legitimate response in all of the circumstances, and that Shangri must face its responsibility at international law.
Your Excellencies, if I may reply quickly in rebuttal. With respect to the first point on the discrepancy between our memorial and our oral argument today, we would submit that upon further consideration of the matter of whether there is a duty in customary international law to prevent the use of its territory as a base, the Shangri government has realized that indeed there is no such obligation, and we would submit that under the rules of the present proceedings, we would have been allowed to depart from our written submissions. On the second point of whether there was notice of the statements made by the SARC President and Minister of Justice, this question really has been canvassed before this court quite extensively, and we would submit that on the evidence there is nothing to show that the Shangri government or the officials that took the decision in fact had such notice. Your Excellencies, they've also stated that the grant of asylum was only in retaliation of a breach of the Hostages Convention. We would submit that the grant of asylum in response was one against Yokum's interception and diversion of the Shangri aircraft, which was first a use of force, second a breach of the customary international law rights of overflight. Third, Your Excellencies, or rather fourth, Your Excellencies, with respect to a breach of a multilateral treaty, we would submit that the terms of Article 60, paragraph 2 are clear, and that the terms of a multilateral treaty may be suspended if there has been a material breach. Your Excellencies, that would conclude our rebuttal.
On behalf of the court, I'm sure I speak for everyone here, we'd like to thank you both very much for excellent presentations, and we will now retire to deliberate the matter. The registrar will inform you what you're supposed to do. Thank you.
The Honourable Court is adjourned.
Please be seated. Somehow this doesn't seem quite right. Well, this has been perhaps the most difficult deliberation of any Jessup competition that any of the panelists here on the bench have ever participated in. As I'm sure the audience realizes by now, it was extremely difficult. The panelists were kept over, the competitors were kept over a significant amount of time, which is unusual in and of itself because we typically adhere rigorously to the time limits in the Jessup competition. We were impressed by both teams very much. I think that without going into specific comments here, the judges would be available after to speak to the team members and to give their assessment of the views. However, I'd like to emphasize the fact that both the memorials were excellent and the oral presentations were excellent. And the final decision came down to fractional points, really, and it was not an overwhelmingly clear or even immediately obvious choice, whichever way the team went. Do either of you have anything to add at this point? Okay, therefore we have been asked to decide. However, because this is also a competition, we'll have to keep the tension mounted for a slight period of time here. So the first thing we'd like to do is to issue the Best Oralist Award, which is indeed a distinction because the two teams here have gone through a rather elaborate and very, very competitive process to reach this point. So what you've got are 4 excellent oralists. However, in the opinion of the judges, Ms. Hudson excelled and could you come up here, please? Congratulations. Typically, there is a certain amount of anonymity that attaches itself to the Jessup competition, in part because the teams will go on to other competitions, and therefore the number of the team is used. However, exercising the court's prerogative, we have compelled the registrar to tell us who the teams were now, and we'd like to say that the runner-up team is Singapore. Australia is the 1988 Jessup Cup winner. If someone from the Australian can come up here to accept the cup. It was a job very, very well done. Congratulations, madam. And now somebody has to take this. This one is in trust, I'm told, although there's no deed of trust that goes along with it. To be returned next year. And to Singapore, I'd like to give you the runner-up cup. Now we'd like to ask Jonathan Green, whom I'm sure you've all heard of before, to come up and make a few comments. Immediately after this, I understand there is luncheon in the Yellowstone room for the team members and the judges. Jonathan, would you like to say a few words and clarify this?
Just a clarification.
Thank you. Another clarification. All right, that's for the winning team members and the final round judging panel. First of all, I heard, although we were running around upstairs, finalizing everything, all your results are ready for each and every team. Book awards are also ready for you. I did, however, hear that we had a very fine panel today, and I think they deserve a fine round of applause. As I mentioned, up in Suite 888, each team has their packet with results, the team score sheets. Also, there will be book awards available. The book awards will be given out from the lowest ranking to the highest in priority. And we have our interns up there. They'll be announcing the team names, and if you're there, you can pick a number of books. They'll be in various categories, and you're free to choose which you like. Also, if you haven't individually registered, left your permanent home address for our participant list, which will be distributed in another month or two, please do so. We also have the House and Senate passes available up there if you haven't received those yet. Finally, I thank you. I wish you a safe trip home. It was a fine competition. Again, thank you and good luck next year.
Fiona.
Would you like me
Oh, yeah.
20 minutes?
Of your cups. I see. You should have written